The records of the selection revealed that the petitioner had indeed secured more marks than the respondent number 4 in the written examination. To be precise, the petitioner had secured 60 marks, whereas the respondent number 4 had secured 48 marks. However, as per clause 2 of the selection methodology, the minimum percentage of marks stipulated in the written segment is 40%. And there is no dispute in the bar that both the incumbents had secured the qualifying marks and eligible for the SPPT. In the SPPT, the petitioner has been held to be not passed, whereas the respondent number 4 has been held to be passed. In the opinion of the court, the relevancy of the higher marks in the written examination amongst candidates would come only when such candidates are found to have passed or be qualified in the SPPT. At this stage, a submission was advanced on behalf of the petitioner that though the petitioner was held to have not qualified in the written segments, even the respondent number 4 had not qualified in certain segments of the SPPT. Emphasis have also been given on the aspect that the respondent number 4 had not passed the proficiency test regarding confidence in driving. A minute observation of the records would show that even the petitioner had not qualified in the aforesaid aspect of confidence in driving. Further, while the respondent number 4 has been held to be qualified in 6 out of 8 segments of skill test and proficiency test, petitioner has been held to be qualified in 3 out of 8 segments of skill and proficiency test. Further, this court finds force in the contention clarification made on behalf of the IOC on the aforesaid aspect that the decision to hold a particular candidate to be ultimately qualifying or not qualifying was of a committee consisting of experts, and none of those experts are directly connected with the IOC, and therefore there is no element of any bias or malafide. Further, on the aspect of driving, the advertisement in question for the post of junior engineering assistant 4 does not indicate under the area of experience that there was a requirement to have expertise on the field, and the only requirement was to have a heavy vehicle driving license. This court has noted that the selection methodology is not the subject matter of challenge, and the same clearly stipulates that the marks obtained in the written test is of qualifying nature, wherein a minimum percentage of 40 has been stipulated. As observed above, the relevancy of marks in a written test would have a bearing only when a candidate is held to be qualified in the SPPT. In the instant case, petitioner has been held to be not disqualified in the SPPT conducted by a committee of experts without any substantial allegation of bias malafide which is apparently discernible or can be perceived. It would not be prudent on the part of the court to interfere with such selection and appointment. Writ petition stands dismissed. Records returned.
Alio.
You take back the records, madam?
Yes.
Item number 13, my lord.
Just a minute, please. He disqualified, not qualified. Smart suit. Item number
13, my lord.
13.
One.
Yes.
But I couldn't read my here because the supplement came out so late. Well, only for the date. Okay.
13 of which year?
21. It's a
21.
challenge to the findings of a disciplinary proceeding, my lord.
21 matter. Okay, 21 will accommodate.
And
But
he has to argue.
your reason is not acceptable. Supplementary list came out late for everybody.
We have to argue the very
Even
merits
for
of
this
the
court, the supplementary list came out late. But we are prepared. You are prepared with one case. We are prepared with 13 cases.
We have to go into the very merits of the entire.
Okay. When? Other side?
Only for the team. We
other-
appear for the petitioner, my lord. Other side is the.
You're for the petitioner.
My lord, the causes reflects wrongly. We appear for the petitioner.
I was wondering what has happened.
Yes.
Okay, who's for the other side? Skate, yes.
Yes.
Other- Okay, when? A prayer for adjournment, but this was by order? This was by order?
My lord, I have checked, my lord. There is no mention. We have never mentioned. I checked in the morning. No mention was. Nagor, where's the bike?
Where is song? Or notes it song? Notes it also? Yeah, I see. This matter has been listed with the endorsement B/O. Full stop. However, the learned counsel for the petition, however, Sri R. Bharadwaj, learned counsel for the petitioner submits that there was no such mention. Full stop. Be that as it may, comma. A prayer for adjournment has been made by him. Full stop. Para. List on. List after a week.
My lord.
List after a week. 1-3.
Apply.
List after list after the week for hearing.
May I please, Your Lordship? In item number 8, I prayed for adjournment for 2 days. In
2
fact,
days.
2 days.
By order.
Uh,
15 matter. Why?
My senior counsel's father's death anniversary was tomorrow. He was in the broad and all the arrangements are there.
Who is your senior?
Satyajit Sharma, S. Sharma.
Okay. For that reason, we'll yes. Other side.
Other side.
Okay. Personal reason. Otherwise, will not grant adjournment in 15 matter. A prayer for adjournment has been made on behalf of Sri S. J. Sharma, learned counsel for the petitioner on some personal grounds. Full stop. Para, considering the grounds as well as the aspect that the writ petition is of the year 2015, a short accommodation is granted. Directing listing of this matter when?
Thursday, this Thursday.
Thursday is okay. On day after tomorrow. Huh? That will be second.
Yes.
Second, 2-5.
Hello.
I have it on, if tomorrow is the pious ceremony, have it on third. Third is okay for you?
Okay.
It's up to you. If second is okay, second. Okay, second. It's your prayer. Second.
Hello.
2-5. Okay.
Your Lordship, I'd like to mention item number 12 on the supplementary list.
Hmm.
And for the respondent number 2, there has been a change in counsel. And the lead counsel is dealing,
Supply code. Supply. Item number
is the same list, Your Honor.
12, yes. Oh, 12, okay.
12.
Yes.
There's been a change in counsel and the lead counsel is dealing with a personal medical emergency.
Who's the presently counsel? Who's
Karan Khanna,
hmm?
Mr. Karan Khanna. For the respondent number 2, ma'am.
Okay. You're for the respondent number 2.
Yes, ma'am.
Okay. You inform the other side.
Yes, I'm for the petitioner, Your Lordship.
We will have another date.
Yes, Your
Next
Lordship.
Tuesday. Is it okay?
We agreed on 9th of May if permissible, Your Lordship.
9th is okay. Thursday. Okay. Our prayer for adjournment has been made on behalf of the respondent number 2.
Yes.
Full stop. List on as agreed to by the learned counsel for the party. List on 9-5 for hearing.
Obliged.
Yes, please, Lordship. Lordship, I beg to mention item number 7.
7 years.
Lordship, senior counsel Ekta Purkasta, Mr. Ekta Purkasta would not able to come today, Lordship, because he is hospitalized, Lordship.
Okay. Yes, social welfare. Some personal reasons. Okay. This has been this court has been informed that Sri A.K. Purkasta, learned counsel for the petitioner, is not well and has been hospitalized. Full stop. Full stop. And accordingly, a prayer for adjournment has been made. Full stop. Para. Considering the above ground, matter is adjourned to be listed on if it's an old matter, we'll fix a date on 9th. 9-5. Okay. Madam, Bora,
Lordship, Mr. S. Toto will appear in this matter, Lord.
but who is appearing for the petitioners?
His name is reflected R.P. Sharma, senior advocate.
None appears for the petitioner on call, whereas Ms. J. Bora, learned counsel, represents the PNRD department. Full stop. Para. The a similar situation. was there on the last occasion when the matter was listed on 22/2/2024. Full stop para. In the interest of justice, a further opportunity is granted to the petitioners to make representation. Full stop. List on day after tomorrow. Huh? No, day after tomorrow.
Lordship.
It is, however, made clear that in case of further non-representation, this court would pass appropriate orders, as this matter is of the year 2013.
Obliged, my lord.
Very good. So here, that's Mr. S. Bautaku, he is conducting the case law. So he's on his way, Lord. So this madam, after some time.
Okay, but we'll have it today, 13.
Yes, yes, your Lord.
My lord,
Transport Department.
Lordship WMD regarding
And so,
bench,
WMD means?
minority development.
Welfare and Minorities Development Department.
After some time.
We have filed our affidavit with my lord, may I dispose of this matter.
For AG. AG.
Yeah.
Okay. After some time,
Yeah.
Mr. Bota will come.
Lordship may kindly accommodate me, I have.
Yes, yes.
Give you-
Obliged.
The petitioner has long back retired from service. Only thing remains, Lordship will kindly see he retired as a civil engineer of minor irrigation department. Lordship kindly see only the order dated 5/6/5, order dated 8/1/2015.
Hmm.
In 5/6/5/2014.
565. Order dated
8/1/2015.
8/1.
2015.
Yes,
May I read, Lordship?
yes, please.
Those several connected issues relating to the promotion to various rank in the education department arise for consideration in this bunch of cases. For the prevent to the present, the controversy can be confined to the post of civil engineer minor irrigation. Mr. Goswami learned from submit that even if the grievance of his clients, the Osimdev Goswami are kept aside for the time being, he is still the senior most additional civil engineer in the irrigation department as on date. One post of civil engineer in is lying vacant. He is therefore entitled for promotion of the said post, at least now, notwithstanding his superstition in the past. There is no justifiable reason is in not promoting him to the post of all, at least in allowing him to hold the charge of the state post, more particularly in view of the imminent subordination on 31/3/2015. Ahmed Learned Council submits that out of the 2 posts of chief engineer in the irrigation department, 1 post of chief engineer of minor irrigation is lying vacant. He further submits that DPC is being convened on 21/2015 for selection to the candidates to fill up the said vacant post of chief engineer. In the proceeding before the court on the Department of Municipality, Osimdev Goswami submitted that petitioner Sri Osimdev Goswami would be definitely considered for giving current charge of the post of chief engineer. In view of this matter, this court ordered that in case the respondent authorities decide to give the current charge of the post of chief engineer to any other person, the same shall not be done without taking leave of this honorable court.
Yes.
Without entering into the controversial issue raised, the bunch of the petition admitted position as on today is that petitioner Sri Osimdev Goswami, the senior most officer in the rank of additional chief engineer in the education department, he is retiring from service on attending a superannuation on 31/3/2001. Having regard to the litigation background and keeping in mind of the previous orders passed by this court, including the order to the demand, court is of the view that passing of the following orders at this stage would meet the ends of justice.
Yes.
Accordingly, following orders has been passed. Respondent of Commission Secretary, Government of Assam, Education Bank shall pass necessary order within a period of 7 days from today, allowing the petitioner Sri Osimdev Goswami to hold the current charge of post of chief engineer in the irrigation department till finalization of selection.
Okay.
So accordingly, petitioner has given the charge of additional chief engineer,
Additional chief.
chief engineer,
Okay.
and he retired.
Okay.
Only thing is that his service has not been regularized till date. Though he has retired from service, DPC has not been, DPC,
Regularized for the period.
DPC.
No, regularized for the period when you had served as chief engineer.
Chief.
That period, yes. Mr. Chakraborty for whom?
But I have filed an implement application. I
For,
was already promoted, my lord.
no,
That
no,
file-
on the aspect of regularization. Are you,
I have not.
you're not the department.
I'm not. I'm-
You're a private respondent.
pri-
Okay,
private.
we'll hear the
Lords.
views. Okay.
Lordship, I'm not getting instruction, proper instruction from my client for inside, Lordship. The old case,
You regularize his service. He has served all the, he's retired now. When did you retire?
he is retired on Lordship 31/3/2015.
31/3.
2015.
Okay.
Only that remains, but nothing.
the instruction came, Lordship, just now, Lordship, that the petitioner name is not appear in the list of Lordship chief engineer.
No, he got the, he served as on in charge basis
Lordship.
after this order of this court. Should regularize the service. If you regularize, he would be entitled for a proper pension in the rank of chief engineer. Now, where is the appointment, Mr.?
Lordship will kindly see WPC number.
Not the appointment as chief engineer pursuant to the
Lordship,
order of 8-1.
Lordship, kindly see page 121
Which one?
of WPC number 5654 of 2014.
121. 121.
121.
Yes, please.
That's the gradation list of additional chief engineer. Lordship got it.
Yes.
Lordship, in pursuance to the report of the screening committee constituted Iman, Honorable High Court ordered the Iman in WPC number Iman. This Iman, the seniority of the officer of additional chief engineer speaks as follows.
Hmm.
Lohit Chandra Pathak and Osimdev Goswami.
Hmm.
Lohit Chandra Pathak has been already promoted. He retired, and I think he is appearing for a private counsel. And petitioner was the senior most that time. Lordship, that is why this court directed that petitioner should be given the charge of chief engineer. Only my prayer is, Lordship, he has retired from service. Only this period he should be regularized.
And now, where is the order of your promotion? Or maybe holding of charge as chief
Lordship,
engineer after
Lordship.
this court's order?
Lordship.
Or tell us the date at least after 1/5/1/8/1
Lordship, I can-
2015.
Lordship, I will give that provided date. Date of
We
join.
want to have a look at the copy of the order,
Yes,
actually. What was was there any
Lordship.
stipulation attached or
Lordship.
anything?
Whether he was given the charge of chief engineer or not.
He has
Have
given
you-
the
have-
charge. There is no
but,
dispute to that effect.
Mr. Goswami, just a minute. Have you applied your mind to the aspect of regularization of his service after 2000? It's hardly for how many days? When did you retire again?
31/3/2015.
2000,
15.
a date?
31/3/2015.
It's hardly for 2 months.
The only question is whether he was promoted to the post of chief engineer or not, or in charge also, Lord.
No, that you'd be aware, aren't you aware?
There is no
I am-
dispute to that effect.
Huh?
There is no dispute to that effect that
No,
petitioner
no,
has-
no, it's
no, no.
not a question of dispute. It's not a fact that you will assert, they'll negate. It's a matter of records.
Lordship.
Whether he was promoted or
In fact,
given
Lordship,
the charge.
the present dealing assistant, Lordship, is going to the board, Lordship. He has not seen the name of Asimdev Goswami, Lordship.
Or as even an in charge chief, this.
Even is in charge.
What do you say, Mr. Pathak? Your client is Pathak.
Lokavidam, my lord, Lokavidam Soika, in item number 9, petition number 994 of.
No, what is your, are you in service?
I have retired, my lord, way back.
Do you have any idea whether the petitioner?
No, my lord, I don't have any.
No, then, no. Otherwise, see, Mr. Chakraborty, we don't want any, we'll, rather you are not, you don't have any role in this
Yes, my lord.
present claim.
Yes.
But if you had any idea whether he had actually served, there is some order. Kindly show it to Mr. Upadhyay.
No, lordship, lordship.
No, you have a look, then we'll have a look. বললেন তো শেষ হৈছে তো চাগে।
Lordship,
It's there, so, okay. We'll finish this off then.
Lost.
Okay, we'll put this on record.
lordship.
You do one thing, we'll direct you to file a representation and you consider positively, not
Lost.
that you negate.
Lordship.
You pass necessary orders because they have to be aware of this. Okay.
Yes.
First we dispose of this implement, there is nothing to be.
My lord.
There is no need actually. We'll finish this off.
Not, it may not be required.
Not very good. Heard Sri S.K. Goswami, Learned Counsel for the petitioner. Petitioner in these two cases. Why the other case?
Other cases were lordship regarding my considering my case in super section, I was in super section. One Digonto Sudri has filed a petition and he has been directed to consider his case for promotion.
Okay, no, in the,
But direct other petition become infractors in view of the
okay,
subsequent.
okay. For the petitioner in these two cases,
Three cases.
three cases, full stop. The also heard Sri Upadhyay,
Lordship, and Upadhyay.
Standing Council. This is Irrigation Department.
Lordship,
Water-
lordship.
Irrigation Department. Full stop. Sri T. Chakraborty is also present, who has filed Miss Case 729/2014 in WPC 994/2014, bring for implement of as party respondent. What's the para? At the outset, comma, the learned counsel for the parties have informed this court that there are substantial developments in this case and the principal relief has already been granted to the petitioner towards his claim for promotion
And seniority. And seniority.
and seniority in the department. Full stop. It is also been informed that the petitioner as well as the private respondents have in the meantime retired from service. Full stop. Para. No, para. The only issue at this stage, as canvassed by Sri Goswami, Learned Counsel for the petitioner, is the issue of regularization of service as chief engineer of the department. Full stop. Para.
Engineer minor lordship, let that one be.
Minor.
Minor.
Minor. No? Para. Sri Goswami. The Learned Counsel has drawn the attention of this court to the order dated 8/1/2015, passed in a bunch of proceedings, including these cases. Full stop. By the said order, comma, the petitioner who was petitioner was directed to be allowed to hold the charge of the post of chief engineer within bracket minor irrigation. पहले भी minor irrigation लिखना है. and his case for regular promotion was to be considered in the ensuing DPC. Full stop. Para. It is submitted that pursuant to the said order, comma, the petitioner was allowed to hold charge of the post of chief engineer, minor irrigation, wide and order dated 22/1/2015, and on 31/3/2015, comma, the petitioner had retired from service. Full stop. Para. Three, para nine, the learned counsel accordingly submits that in spite of the aforesaid order, comma, his services in the rank of chief engineer, minor irrigation has not been regularized. Full stop. Para. Three, Upadhyay, the learned standing counsel of the department, however, submits that there was no instructions as to whether the petitioner was actually given the benefit of promotion to the aforesaid post. Full stop. Three, the role of the incumbent who had filed the implement application in the year 2014 may not be relevant for adjudication of the present issue. The role of the incumbent who is represented by Sri T. Chakraborty may not be relevant हो जाएगा. बाकी सब represented by वो बता para. To resolve the issue which is presently pending, comma, it would be convenient if the operative part of the order dated 8/1/2015 of this court passed in amongst others, the present petition is extracted herein below. Order sheet 8/1/2015 order, the last having read page 7 having say last तक यहाँ तक वो पहला वाला petition में दो Sri Upadhyay, the learned standing counsel, was not certain about implementation oblique outcome of the said order, comma, the said aspect has been put to rest by Sri Goswami, the learned counsel, who has presented before this court a copy of the order dated 22/1/2015 passed by the department, whereby the petitioner was allowed to hold charge of the post of chief engineer within bracket minor irrigation pursuant to the order dated 8/1/2015 as mentioned above. Full stop. Para. In view of the it is also not disputed that the petitioner had thereafter retired on 31/3/2015
After attaining the
on attaining the age of superannuation while holding the said post. Full stop. Para. In view of the aforesaid facts and circumstances and the background observations made by this court, which is recorded in the order dated 8/1/2015, comma, denial of the aspect of regularization of the petitioner in the post of chief engineer within bracket minor irrigation would not be a fair and reasonable action. Full stop. Para. Accordingly, comma, the writ petition is all the writ petitions are disposed of by directing the respondent department to consider and pass consequential order for regularization of the service of the petitioner in the rank of chief engineer, minor irrigation, and consequently to give the benefits which would accrue upon such regularization, full stop. Due to facilitate the aforesaid exercise, comma, the petitioner is directed to submit a detailed representation along with copies of the relevant orders of this court, including a certified copy of the present order to enable the, to the department within a period of 10 days from today. Full stop. The aforesaid exercise as indicated above be completed expeditiously and preferably within a period of 4 months from the date of receipt of such representation.
Only one thing, Lordship, the petitioner was given the additional charge of the post of additional charge. Lord.
Lordship, we keep it in the record.
We will have a copy of the order dated 22/1/2015 is made part of the records. Full stop. All the writ petitions accordingly stand disposed, all the writ petitions, including the including miscase number so and so, well, miscase to separately, no, including so and so, stands disposed of.
Obliged.
Obliged.
Made part of the records. You will return one copy to you. Do you have a copy?
Lordship, I do not have.
No, we will photocopy it. You take one copy also.
Lord.
Mr. Upadhyay.
Obliged.
Obliged.
All matters we should not keep pending.
Sure.
Even one day tomorrow, we do not know what will happen.
Sure.
Full time. Oh, Bora na anything. Mr. Borthakur, we'll have it, request is made by Madam Bora. Let her come, we'll have it. Okay. Mr. Goswami, try to have her. Okay. Yesterday's matter.
Hello. Not the issue here is regarding the termination of the services of the petitioner in the post of Anganwadi worker. The initial order of appointment, my lord will find at page 14.
Page
14 is the initial order of appointment as helper, Anganwadi helper.
date
I know, this is of 26/3/2002.
14. 14.
114, my lord, page 14, annexure A. Office order dated 26/3/2002.
26. Now, see here, it's Anganwadi worker / helper. Your
But
worker,
my initial appointment was as helper. Later it was upgraded to that of a worker, which my lord will find it annexure C.
what is the center?
Number 125, Dhingirati.
125.
Dhingirati,
Where do you get? 125 Sangadri Center. In the order, where is the name? Name.
in the translated copy is at page 14. My lord, the one in vernacular is at page 16.
Now, where is the name of the?
Right at the top, the first line, man. In pursuance of Divisional Executive Officer's approval, Srimati Noorjahan Begum. I am Noorjahan Begum.
You have
Sure.
not given the name of the center.
Center center is number 125 Anganwadi Center.
No, no, of what? What is the name?
Dhingirati is
You
the.
have not given the name. Why this, what translation is this?
No. My lord will find it
Hmm.
at page 17, annexure B. The second last line from the bottom.
Thingarati. This is in which district?
This is Morigaon, ma'am.
Okay. You are appointed as helper in
And-
2002.
So, and later on, my lord, by the order at page 17, the post was upgraded as Anganwadi worker,
Say 5714.
my lord. 5714. Then, my lord, after serving about 21 years continuous service, the services of the petitioner was terminated. My lord, the order of termination, my lord, will find it at annexure C, page 18.
Hazarika, take your seat. We'll come back to you. 18,
18. Annexure C,
23-2.
my lord.
Terminated.
Terminated. No reasons assigned.
Okay.
My lord, it is against the order of termination that have come before it.
Okay.
My lord, will just turn to annexure D, my lord, page 21. That gives the detailed factual account.
21.
21, my lord, page 21, annexure D.
Yes,
I've given a representation
yes.
against the order of termination. Where, my lord, I have given my service, besides giving my service career, the particulars of my service. And I've also pointed out and highlighted the fact that the copies, the premise on which the order of termination was passed, that was not assigned to me. That was not served to me. So, besides not furnishing the required termination, the reasons,
Formulate your grounds, no reasons assigned.
no reasons assigned. And my lord, in view of the fact that no reasons were assigned, my lord, my submission would be that the order is violating of the principles of natural justice,
PNJ violation.
my lord.
Okay.
And my lord, besides that, my lord, my submission would be that there is a need for holding an inquiry in view of the fact that I have negated the stand of the respondents that
No, that will be a larger part of the violation of principles of natural justice.
and an inquiry ought to have been held. If at all there were the
Okay,
complaints,
these are part of the PNJ.
That
We'll consider.
that is my sole.
Is the post held up, filled up by somebody else?
It has since been filled up.
That means there was a need of the post.
There was a need of the
It is
post.
not a case.
I
It is
I
not
don't.
it is not a case that the post was not needed, so you are terminated.
No.
So
no.
there were some allegations.
Yes, Mala, there were allegations and which was denied. And in view of the denial of these allegations, Mala, there ought to have been an inquiry. That is my humble submission, my lord. And besides that, my lord, I have not been paid the honorarium due to me since March 2022. Till the date, at least till the date I was terminated. I mean,
No honorarium since
since March 2022.
March
March 2022, my lord.
till 23.
Till the, yes, sir.
Almost 1 year.
1 year, my lord.
Okay, that is your case.
That is my case, my lord, in short.
Okay. We'll come back to you.
My lord.
Okay, yes.
In para 7 of our affidavit in opposition.
You have filed if in opposition.
We have set out the circumstances, your lordship. It's a long para involving multiple sub paras, your
It
lordship.
doesn't matter.
But,
Just
basically-
just a minute. 7. Which one? 7?
Para 7, page number 35.
Yes, 7 what?
Or para 7 of the affidavit in opposition. Your Lordship.
7 there are 1, 2, 3, 4. Which
Yes,
one?
yes, yes. Lordship, no, I'm just saying that this is our, we have given a narration of the events which led to the.
Okay, understood.
Okay, the fact is that, Your Lordship, initially she was appointed, Your Lordship, thereafter Anganwadi helper post was vacant. The Anganwadi center was in his home. So thereafter the Anganwadi helper, she
The
wanted
center was at her home.
her home. Thereafter, she wanted, our statement is that thereafter she wanted the advertisement for Anganwadi helper arose. The daughter of the petitioner was also in that case, Your Lordship, in that selection process, but she could not succeed. Someone else got got selection as Anganwadi helper,
Petitioner was the worker.
worker.
Hmm.
He was the helper. Thereafter, this led to some kind of a fiction, and there was the complaint from the Anganwadi helper also that she is being prevented from doing the job and everything.
Hmm.
To the extent that initially we had to write a letter saying that the entire Anganwadi center had to be shifted to another place, Your Lordship. That is at Lordship, page number 38, point number X, point number 10.
Okay.
Anyway, Your Lordship, thereafter certain so-called notices were issued, Your Lordship. They were not found to be satisfactory.
Where have you shown?
Copies of letter dated. Lordship, this is not a we have mentioned that the so-called notices were given, Your Lordship. That is in page number 44, Annexure B. Whereas the CDPO had issued 3 numbers of so-called notice to Srimati Nurjahan Begum, white number so and so dated 24/3/22, 25/3/22, and 11/8/21, but the so-called replies were not satisfactory. In view of the above facts and materials of record, I am inclined to arrive at a decision to issue direction to the CDPO Lahori Ghat ICDS project to terminate the voluntary service of the petitioner with immediate effect. Your Lord.
Where are these letters? Or you have given the numbers also?
Numbers, Your Lord. Lordship, these are, I think, in the affidavit in reply, Your Lordship, page number 43 to 46.
Hmm?
Page number 43. Whether these are copies of copies to the reply. The replies he has annexed, Your Lordship.
Says the next.
The replies he has annexed.
Where?
In the affidavit in reply, Your Lordship, page number 43 to 46. Lastly, Your Lordship, the appeal is the representation is pending, Your Lordship, before the department.
Just a minute. Please. Yes,
Otherwise, your lordship, page number 43, your lordship will have a glance.
43 of
Continuous page number, this is the affidavit in opposition, your lordship, Annexure A.
your opposition.
Not-
Yes,
Because the entire thing has been captured in brief by the CDPO, your lord.
yes, Mr. Srinivasan.
My lord will turn to page 43 of their affidavit in opposition.
Yes, yes.
That is the letter issued by the Child Development Project Officer addressed to the director,
Yes,
where, my lord, a reference has been made to complain. Several complaints have been noticed, the performance of duties, etc., vis-a-vis the petitioner. But the complaints, the details of the complaints have not been given, number one, my lord. And my lord, Annexure B, page 44, the order of the director, my lord will find that the director, purportedly acting as a disciplinary authority, has not exercised his own independent mind, but is relying on the report or the letter of the CDPO. There's no independent application of mind.
Mr. Srinivasan, this is not a regular service.
True, my lord, but since
This is a voluntary service for
true, my
which
lord, true, my
you
lord.
are given an honorarium.
I'm aware of that, my lord.
And if there were no materials which you had initially projected, no material at all, that they did not like you, they chuck you out. That is not what has been reflected now. But that appears they had tried to resolve the issue. The CDPO had herself visited this place number of times, tried to resolve the issue.
That is what
After
the affidavit says.
the entire objective of having this is
My lord.
on an entirely different footing.
True, my lord.
These are voluntary services meant for
True, my lord.
children, women. But if you had some personal agenda that your daughter should be, of course, if there is an allegation, we were concerned whether you are given an opportunity. We find opportunity was granted. We may not go for adherence to the strictest need as we do in a departmental proceeding. We cannot equate this to be a departmental proceeding.
True, my lord. True, my lord. But I would only humbly submit,
But
my lord.
how do you run a center? It's not a case that some allegation that you are not discharging your duties properly. You have agenda to have your daughter, you do not allow the helper to function. They have been trying to resolve the issue 3 occasions. How do you run the center?
But a
Center
modicum,
had to be shifted.
my lord, the center is back where it is, my lord. And that the center where the location of the center is in the land donated by the petitioner. That would only go to show the bona
for
fides
that-
of the petitioner.
No, you have donated this land, you have got the job also. You are
But-
trying to induct your daughter also. no?
Now both the petitioner as well as the daughter, they are out of service and she has not been paid her honorarium. But my submission may perhaps, my lord, only should there have been a modicum of an inquiry. That is what the Supreme Court says in the latest decision, my lord.
Okay,
There-
we will consider,
My lord,
we will consider.
my lord, my lord.
He and Srinivasan, Learned Counsel for the petitioner. Also heard three, C. S. Hadarika, Learned State Counsel for the official respondents. Para, please have your seat. The challenge in this writ petition is against the action of the respondent authorities in terminating the services of the petitioner as an Anganwadi worker, full stop. The principal ground of challenge is violation of the principles of natural justice and not adhering to a fair procedure. Full stop. An additional issue of non-payment of the honorarium for a particular period has also been raised. Full stop. Para. The facts projected are that wide an order dated 26/3/2020, 26/3/2002, the petitioner was appointed, the services of the petitioner was engaged as an Anganwadi helper in the number 125 Dhingarati, DHINZARATI, Anganwadi Center in the district of Murigaon. Full stop. After serving in the said post, the said services of the petitioner was upgraded to the post of Anganwadi worker, wide an order dated 5/7/2014. Full stop. While discharging her duties, it is the case of the petitioner that wide an order dated 23/2/2023, her services were terminated. Full stop. The petitioner claims to have submitted a representation on 9/3/2023, which has not been considered, and accordingly, the present writ petition has been filed. Full stop. Para. Srinivasan, the learned counsel for the petitioner, has formulated his challenge in the following manner. Number one, the order of termination does not assign any reasons, and therefore such termination is arbitrary and unreasonable. Number two, the impugned order does not reflect that the petitioner was given a fair opportunity to defend herself, even assuming that there were some allegations qua the services rendered by her. Number three, there was no inquiry conducted to come to a finding whereby allegations, if any, were held to be substantiated. Full stop. Para. The learned counsel, as indicated above, has also has also contended that the services, that the honorarium for before her termination has not been paid to her, full stop. To be more precise, comma, the period has been quantified from March 2022 till the date of the termination of her services, which is in February 2023, full stop. Para. Per contra, comma, Sri Hazarika, the learned State Council, has submitted that the factual projection made by the petitioner is not correct, full stop. By referring to the affidavit in opposition filed by the respondent number 7 on 1/8/2023, comma, the learned State Council has submitted that the center was initially at the residence of the petitioner, full stop. When after upgrading the services of the petitioner from Anganwadi helper to Anganwadi worker, comma, there was a requirement of filling up the post of Anganwadi helper, in which the daughter of the petitioner was one of the aspirants, full stop. However, comma, in the selection held, comma, the daughter of the petitioner was not successful, and thereafter, comma, the petitioner had created problems for the selected Anganwadi helper in joining and discharging the duties, full stop. Consequently, comma, the functioning of the center as such was hampered, and the entire objective to have the center was being defeated, full stop. It is submitted that even that to overcome the said situation, comma, even the Anganwadi center had to be shifted to another location, full stop. Para. As regards the aspect of not giving opportunity and the issue raised of violation of the principles of natural justice, comma, the learned State Council has submitted that 3 numbers of communications in the form of show cause notice were issued to the petitioner, full stop. In this connection, comma, reference has been made to the communication dated 22/2/2023 issued by the Director, comma, Women and Child Development, which would reflect the details of the aforesaid 3 numbers of so-called notice, full stop. It is submitted that in the affidavit in reply, comma, the receipt of such show-cause notices would appear to have been admitted via the communication dated 8/7/2022 made by the petitioner, full stop. The action for termination of the services of the petitioner had to be taken in the public interest and was done by following the due process of law. Full stop. Para. In his rejoinder, comma, the learned counsel for the petitioner has submitted that though there is a reference of certain complaints, comma, the details of such complaints are not reflected in the impugned order. Full stop. Para. The rival submissions made by the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. Para. The grounds of challenge as observed above are mainly towards not assigning reasons for terminating the services and the action being in violation of the principles of natural justice. Full stop. Para. Before going into the issue which has been raised in this petition, comma, it has to be reminded that the post in question is of a voluntary nature. And the post in question involves voluntary services and only honorarium is paid, full stop. It cannot be equated with a normal civil post, public government post, wherein such services are governed by a particular set of rules. Full stop. Be that as it may, comma, if be that as it, comma, it is equally true that before any adverse action is taken qua the services of an incumbent, comma, the principles of natural justice is required to be adhered to, full stop. It is therefore required to be, what is therefore required to be examined in this case is as to whether such principles of natural justice were adhered to or not, full stop. Para. The projection made by the petitioner that no reasons were assigned and no opportunity was granted does not appear to be consistent with the materials on record. Full stop. The order dated 22/2023 of the Director, Women and Child Development, Assam, which was referred to by the learned State Council, has specifically mentioned 3 numbers of show cause notices, which are as follows. Page 44. Number diba, page 44. Number, date 1, 2, 3. Full stop. This court has also noticed that in the show cause reply, in the affidavit in reply filed by the petitioner, comma, she has annexed a reply to the show cause notice, wherefrom it is apparent that she was aware of the reasons as well as the fact that due opportunity was granted to her to defend herself. Full stop. The reasons which has emerged, of which has appeared from the materials on record, would go to the root of the matter, which involves a smooth running of the center, of the Anganwadi center in question. And it appears that the petitioner was acting as an impediment in the smooth running only because of the reason that her daughter was not inducted as an Anganwadi helper in the said center. Full stop. The requirement to shift the center from the place, from the earlier place, which was the residence of the petitioner, has also been brought to record. Full stop. Para. Under the aforesaid facts and circumstances, this court is of the considered opinion that the present challenge, that the present challenge is not sustainable. More so when the grounds taken in support of such challenge does not appear to be substantiated. Full stop. The writ petition accordingly is held to be without any merits and dismissed. Full stop. However, dismissal of the writ petition is only on the aspect of the termination of service. Full stop. The other aspect regarding non-payment of honorarium for the period from March 2022 to the date of termination, however, is also required to be redressed. Full stop. The respondent authorities are accordingly directed to pass appropriate orders towards payment of the necessary honorarium to the petitioner for the period in question within a period in question. Full stop. The said exercise be undertaken and completed within a period of 90 days from the date of receipt of certified copy of this order. Writ petition stands disposed of.
Obliged. All right, my lord.
We hope this smile will remain towards the end also. You never know.
Yes, madam.
Formidable opponent. Yes.
The issue is whether the employee of some minority development board is entitled for retirement benefit or not, madam.
Who are you?
No, we are working as a peon, madam. Driver.
How many of you are there?
Seven numbers, madam. The petition, in the meantime, madam, during the pendency of this petition, madam, 6 and 7 has been retired, madam.
Seven
Petition-
numbers of petitioners.
Yes, madam. And
Who
out
are
of
retired?
6 and 7, madam.
P6 and 7 retired. Five are there.
Yes, madam.
5 are remaining.
Yes, madam. And the petition number 1, madam, is working as a peon.
Yes.
And petition number 2 is working as a driver. 3 is madam peon.
They are working as peons and drivers.
Yes, madam.
And
IB is madam working as a stenographer grade 3, madam.
that means they are grade 3 and grade 4.
Grade four,
employees. Okay, petitioners grade 3,
Yes.
grade 4 employees.
Now, initially, madam, in 1988, madam, from my 1985, madam, the petitioner was madam appointed by the Assam Minority Development Board, madam.
Assam
Minority Development Board.
Development Board.
Yes, madam.
This was your employer?
Yes.
Okay.
Now, in the year 1987, the government has sanctioned the post, my lord.
This board was constituted when?
Much earlier, my lord.
Okay, doesn't matter. 87 boards were sanctioned.
Yes, ma'am. I will kindly see page number 36, ma'am.
Board was framed on 1985.
Board was constituted. A page? Page, Mr. Bhattakur,
Yes, ma'am.
sanction?
Page 36, ma'am.
36.
The government has conveyed the sanction, ma'am, for creation of this post, ma'am.
28 to
28 to 1987. May I read, ma'am?
yes, post sanction. Now doesn't matter.
Yes, ma'am.
Okay.
But this sanction was given, ma'am, after concurrence of finance department, ma'am.
Stenographer 1. LDA 1.
LDA 1.
Peons 2.
Yes, ma'am. Now, ma'am, thereafter, ma'am,
Where is the post of driver?
page 39, ma'am.
39. Yes.
I say it is, ma'am, UDA and driver, ma'am.
Subsequent sanction.
Yes, ma'am.
39.
Yes, ma'am.
This is 29 December.
Yes.
29/12/87.
And subsequently, ma'am, in page number 42, ma'am, one post of peon also has been created, ma'am.
Okay, no problem. The
Yes.
post are sanction post.
Yes, ma'am. Now, in page number 46, ma'am, the page 46, ma'am, can you see, ma'am?
46.
Yes.
Yes,
The-
yes.
Government has primarily retained this post, ma'am.
Okay.
Including the director, ma'am.
Yes.
And in page number 48, madam, the CPF account has been created, madam, in favor of us.
48.
Yes.
Okay.
Now, madam, the page 50 is important, ma'am.
Page
Page 50.
50.
Yes. The director, madam, requested the madam, government, madam, the Joint Secretary of Government of Assam Welfare of Minority Development Department, madam. Now it comes under, madam, Welfare Minority Department. madam.
Director wrote to the department.
Yes, madam.
What did he write?
He requested, madam, as the madam, CPF account has been created, madam, to regularize the pension, madam.
Yes.
Against this matter letter, madam, page 51. The director's request has been declined. Page 51.
Declined.
Yes, ma'am.
Page 51.
Page 51. He says, madam, since the board is a was constituted under Society Registration Act, madam. So we are not entitled for any pension, madam. And which is followed by page 52, madam.
Yes. 52.
52, madam.
Okay,
my lord, can you say page 54, my lord, the salary has been given by the government, my lord. Page 54.
54.
54 and 55, my lord. The government has sanctioned the my lord, guarantee rate, my lord, which includes my lord, the salary of the employee, my lord.
Yes.
About the respondent, my lord, the government now taken a decision, my lord, this time that since we are appointed, my lord, by the board, my lord, we are not entitled for any regular pension or other retirement benefit. This is the only stand taken by the them, my lord. Now, my lord, whether my lord, rule 31 of Assam pension rule come into play or not, my
I
lord.
saw it, Rule 31. Assam pension rule. Okay.
He says that the service of an officer does not qualify unless it confirms on the following three conditions. One, the service must be under government. The employment must be substantial and permanent. The service must be paid by the government. And my provision, my lord, provided that the governor may, even though either or both of the condition 1 and 2 above are not fulfilled, declare that any specific kind of service rendered in a non-gazetted capacity shall qualify for pension.
Okay.
Now, in rule 36 is also important, madam.
30?
36, madam.
Yes.
Service does not qualified unless the officer holds a substantive office on a permanent establishment, provided that continuous temporary or officiating service under the government of Assam followed without interruption by the confirmation in the same or any other post shall count in full as qualifying service except in respect to 3 years for temporary or officiating service in non-pensionable establishment. Period of service paid from contingencies. Now here, madam, in our case, madam, since the post has been created by the government of Assam, and post has been permanently retained by the government of Assam, my lord.
Yes.
Initially, madam, our employment is comes under my lord, Assam minority board, my lord. Now, it subsequently is comes under the department, my lord. And government has permanently retained the post, my lord.
It is now under the department.
Yes, madam. So, but the director is a my lord. Is a SES post, my lord. He has been paid by the government, my lord. I have already seen, my lord, in page number 46, when the government has sanctioned the permanent retention to the post, my lord.
Okay. What else?
I am relying on the my lord. Polling Gupta, my lord. Yeah. Here, the petitioner was appointed initially by the Tribunal Autonomous Council, my lord. And thereafter his post was, my lord, regularized by the government of Assam, my lord. And his pension was not released.
Yes. Para?
Prayer 10 and 11, my lord.
Yes.
May I read?
Yes. Now here are the services was with the council, Karbi Angan Autonomous Council.
Yes, my lord.
That's a creation under the sixth schedule.
Yes, my lord.
How can you
But-
equate?
That is the, my lord, they are objection of the respondent there, my lord.
No, it is under the sixth schedule. So the obligation of the government would be somewhat different. How can you equate this?
Unless you agree.
There are other case laws. Why don't you equip with those case laws?
The master worker, my lord.
Not master or worker, regarding cases which will really help you for societies which are controlled by the state. What will happen to the employees of the society? Can you leave those employees high and dry after the retirement? There are societies which are
Yes, my lord.
normal, ordinary societies. There are societies which are controlled and run by the state.
Here also, the
So if
again-
it is a society which the state is having full control, even the
Yes.
retention of the post is by the state, then can they be treated in a different class than the employees of the state? If not, you have to be backed by a case law.
if my lord allows me about 2 days time, my lord.
Why allow you 2 days? What did you do? These are matters of 2013. This is the first question and the only question which they will raise and you have
Yes.
to answer. That your services are different. It's not, you cannot be treated or equated with the services of a state government employee. You're an employee of the society.
Since the salary has been paid by the government, my lord, not a guaranteed end also, my lord.
That will not take away or do away with the first objection that you are employed with a society. It's
Yes,
a registered society.
Yes.
Now, how do you difference?
Even though, my
between
lord, the subsequently, my lord, the post has been created by the government, my lord,
It's not created, it's retained.
or retained, my lord.
Yes, madam.
Lordship, first of all, the petitioner claiming that they are the government employee. But in the petition, they have not annexed any document showing that their appointment order, regularization as the order, etc. Now, I am submitting from his documents only, my lord. Page 46, my lord, may kindly have a look. Annex the 6,
Yes.
page 46, ma'am.
46, yes.
Yes. It's written from the Deputy Secretary, Welfare Management Department to the Accountant General, so and so. Subject permanent retention of the post of the Office of the Assam Minority Development Board. Sir, I am directed to convey the sanction of the Governor of Assam to permanent retention of the following post for aforesaid office in the scale of pay so and so as given below. Then the last para, my lord. The expenditure is debitable under the head of account 2070 other administrative service 104 Special Commission of Inquiry, Assam Minority Development Board, 3101 granting aid, that is salary, non-plan general voted for the year, so and so. This is the granting aid. This is not the government is paying their salaries, wages, etc. We are giving only the granting aid. Your lordship may kindly have a look, page 52. Annex 10. Annexure 10,
52.
Lordship.
Yes.
Since earlier, the director has by letter dated 25th April 2013 retained the department for their pension, and we have replied to their letter, and we have said the department written to the director, Minority Development Board, that, sir, with reference to the letter and the subject cited above, I am directed to say that Pension and Public Grievance Department has observed that the service of Assam Minorities Development Board do not fall under the purview of Assam Service Pension Rules 1969. So it is clear in 2013, they are not under pensionable service. They are not government servant. We are not appointed them. There is no appointment order. There is nothing regulation or there nothing else. Lordship. The petitioner cannot say there are 4 posts we have sanctioned. That does not mean that we have sanctioned the post for the petitioner only. They have not shown anything, no documents annexed in this petition in their name. They have engaged by the department, they have engaged by the government against us any sanction post. Nothing is there. Then Lordship may kindly have a look my affidavit.
Then who are working in this post which were sanctioned by you?
They are the board employee. They have engaged for their day-to-day regular basis, my
And
lord.
page 46, which
My
you
lord.
just shown. No doubt it is debitable from the grants in aid,
My lord.
but you see the language of page 46.
What is the detention?
Retention, I am directed to convey, this is by the department, okay, to the AG.
My lord.
To retain, convey sanction of the governor of Assam for permanent retention of this following posts. You
Yes,
have seen that the post, there is 1 post of driver, 2
Yeah.
posts of driver,
Yeah.
2 posts of peon, then LD assistant, UD assistant, stenographer, etc.
yes. But
Now-
these are not sanction post, my lord. We have retained the post for the board in the granting aid. We are given them the granting aid, not the salary. In a company also, Lordship is well aware that AIDC is a company under the Industries Department. Their employees are not entitled for any pensionary benefit. They follow the Companies Act. In such similar situation, these board are registered under the society and there is no pensionary benefit at all. These posts are not
So,
sanctioned.
what do you, after the retirement, what do they get?
Only some, not pension, but some lump sum, GPF, etc. they are getting.
What do you
Okay.
get, Mr. Botakur, otherwise?
But they will get them a retirement benefit also, my lord, the leave engagement,
That they will get.
Leave encashment and what else?
regular. And then leave engagement, my lord, GPF,
Except the pension, others they will get.
GPF you are getting.
yes, my lord. My lord, kindly see that their appointment, my lord, for page number 26, my lord. Why they have retained, my lord? It is copy and marked to the government, my lord. Page 26, my lord.
Okay, yes.
Lordship, may I submit for my affidavit, my lord? From paragraph 4, my lord, is page 2. Paragraph 4. May I read, my lord?
Page 56.
Page 2, my lord, in my affidavit.
Running page is it 56? Who is
Oh,
the,
page, sorry, my
who's the
lord.
dependent? Aga Ahmed.
My lord. The only affidavit filed in this petition, my lord, is from the department. Page 2, paragraph 4, my lord. May I read, my lord?
Paragraph 4.
4 onward, 4 I'm
Second
reading.
page.
Yes, my lord.
Please read.
That with regard to the statement in paragraph 12 of the repetition, the deponent begs to state that the Assam Minorities Development Board, which was framed on 4th April 1985 and registered as a society under the Societies Registration Act 1960. It is stated that the state government may provide fund to the board in the form of grant in aid. The board is responsible for managing the affairs of Assam Minorities Development Board, including payment of staff engaged to perform tasks of the board. The services condition of the petitioners are governed by service rules of the board, if any, and as such not governed by pension rules of the state government. The deponent further state that the Pension and Public Grievance Department has rightly observed that the services of the staff of the Minorities Development Board do not fall under the purview of Assam Service Pension Rule 1969. Then Lordship, 5, that with regard to the statement made in paragraph 13 of the petition, the deponent begs to state that the Assam Minorities Development Board is run by the Board of Directors, that the board is structured as a registered society. Then Lordship, the paragraph 7, That with regard to the statement made in paragraph 15 of the writ petition, the deponent begs to state that since government of the Assam provide grants in aid to the Assam Minorities Development Board and the post of the Assam Minorities Development Board were accorded permanent retention by the government. However, permanent retention to the post do not grant eligibility of pension as the petitioners are engaged by the board, which is governed by Societies Regulation Act and Memorandum of Association. Then Lordship, paragraph 9. That with regard to the statement made in paragraph 18 and 19 of petition, the deponent begs to state that, as per record in the Director of Assam Minorities Development Board, has simply forwarded the prayer of the petitioner to the Welfare of Minorities Development Department for consideration only. The Department of Pension and Public Grievances under the Assam State Government had rejected the proposal. The deponent reiterated the reaffirmed the fourth paragraph. Then, their Lordship, this is my submission, and 18 is relevant. They have again stated that with regard to the statement made in paragraph 43 of the petition, the deponent begs to state that the board is registered under Societies Act 1860 and governed by Memorandum of Association, and therefore Assam pension rules are not applicable to the staff to the Assam Minorities Development Board. Hence, the writ petitions could be liable to be dismissed. And Lordship, I am relying on judgment of the Honorable Apex Court. This is very much similar to present. Lordship, it's a very short judgment. It's 2009 5 SCC 694. I'm relying paragraph 9, 11, 23. So it's a very short judgment. May I read the whole judgment, Lordship? Because this judgment is passed against the dividend bench judgment of this honorable court, my lord, by the Apex Court. Lordship, permit me, may I read the whole judgment? Very short, my lord. This appeal by special leave is filed by the state of Assam, agreed by the order dated 14/6/2001, passed by the division bench of the Guwahati High Court. By that order of the division bench, upheld the order dated 23/12/1999 of the learned single judge in civil rule number so and so, allowing the respondent's writ petition and directing the state government
What was Kamul CMUL?
Kamul Kachar and Karimganj Mill Production Unit.
Sir, and
Kachar and Karimganj District Milk Producers Cooperative Union Limited. In short, is Kamul.
where is it?
It is in paragraph 2, Lordship.
Paragraph 2, Kachar and Karimganj
My lord.
District Milk Production Cooperative Union Limited.
It's a society, my lord. May I continue, my lord?
Yes. Cooperative Society. Yes to know. This Kamul was under the Cooperative Society.
My lord.
Registered under what?
Societies Act.
No, it is under the Assam Cooperative Societies Act.
My lord.
49.
Lordship.
And they are registered under what?
They are also registered under, it is a society, Lordship, registered under 1960. Society Register Act.
The society's registration, it's not a cooperative society's registration.
But their entities same, my lord. They registered society. Their function may be different. That's why they are registered under different society, but they are the registered society.
Okay.
Both of them are registered society. The fact is very similar. The Lordship, allow me, I will continue
Yes, yes.
reading, my lord. By the order of the division bench, upheld the order dated 23/12/1999 of the learned single judge in civil rule number so and so, allowing the respondent's writ petition and directing the state government to sanction financial assistance by way of granting aid to Kachar and Karimganj District Milk Producers Cooperative Union Limited, Kamul for short, so as to enable Kamul to make regular payment of monthly salaries, allowances, as also the arrears to its employees. Kamul is a society registered under the Assam Cooperative Societies Act 1949, the Act in for short. The respondent, that trade union representing the workers of Kamul, so and so. This is the fact, Lordship. The Lordship, 4, my lord. It is contended that the state government had all pervasive control over the affairs of the management of Kamul, and therefore it should be treated as a department of the government of Assam, though registered as a cooperative society by lifting the cooperative veil. It was further contended that the state government was responsible and liable to pay the salaries and emolument of the employees of the Kamul, and it was not justified in withholding the grant amount. The Lordship, some other facts has been discussed here. We can avoid this. Paragraph 9. Lordship, may straight away paragraph 9. The various averment of the respondent in the writ petition about the all pervasive financial, administrative and financial control of Kamul by the state government, even if assumed to be true, may be at best result in Kamul being treated as state within the meaning of that expression under Article 12 of the Constitution of India. If it is a state, in case of violation of any of the fundamental right of its employee, like by Kamul as an employer, and the employees were entitled to claim relief against Kamul by taking recourse of a writ petition under Article 223 of the Constitution of the India. But the fact that a corporate body or a cooperative society answers the definition of state does not make it the state government, nor will the employees of the such a body becomes holder of a civil post or employees of the state government. Therefore, the fact that Kamul may answer the definition of state does not mean that the state government is liable to bear and pay the salaries of these employees. Then 11, my lord. Therefore, Kamul, even if it was state for the purpose of Article 12, was an independent juristic entity and could not have been identified with or treated as the state government. The view we have taken, it is not necessary in this case to examine whether Kamul was state for the purpose of Article 12. Your lordship, kindly have paragraph 23. Today's lordship, the other judgment was reiterated in this judgment, my lord. 23. What clearly holds the field at present is the principle laid down by reiterated by the Constitution bench of this court in Steel Authority of India versus National Union Waterfront Workers, wherein this court categorically held, paragraph 37 of this judgment, we wish to clear the air that the principle, while discharging public function and duties of the government, companies, corporations, societies, which are instrumentalities or agencies of the government, must be subjected to the same limitation in the field of public law, constitutional or administrative law, as the government itself does not lead to the inference that they become agents of the central state government for all purposes, so as to be bind such government for all their act, liabilities and obligation under various central and or state act or under private law. So in the last paragraph, we therefore reject the interpretation put forth by the respondent on the tentative observation in Kapila Hingramani and Kapila Hingramani 2 to contend that the government would be liable to payment of salaries and other dues of employees of the public sector undertaking, whereof the considered future decision of the High Court cannot be sustained. The lordship is the case where this case is covered, madam. In fact, if lordship may kindly have a look, the rule 31 of the Assam pension rule, they are not covered by 31. 31, lordship may kindly have a look. Lordship has the book, Assam pension. 31.
Yes.
31, condition of qualifying service. The service of an officer does not qualify for pension unless it conforms to the following three conditions. Firstly, the service must be under government. Secondly, the employment must be substantive and permanent. Thirdly, the service must be paid by government. So, lordship is aware these petitioners are engaged by the board. They are not appointed by the government. Their salaries are not paid by the government. They are not government servant at any cost. So they are not, and they are well aware at the time of engagement, their service is not under pensionary service. We have cleared, the pension department has taken their view and they have written to us. We have informed them, you are not under the pensionable service. Now after retirement, they are before this honorable court for their pensionary benefit. My lord may dismiss this writ petition. This is my humble submission. I am obliged, my lord. An accountant general also party here.
Yes, Mr. Medhi, anything?
For 31 of covered, 31 of check.
Yes, when 31 of pension?
Pension rule, my lord.
Yes.
The post take hold, my lord. My already friend, the before is not report, my lord. The service of the petitioner does not qualify for the pension unless informed the following frequency. The service must be under government. The employment must be substantive and permanent. And the service must pay by the.
Not abstract and rule 31, my lord. They are not entitled. Please, ma'am.
Well, kindly see, even if, my lord, we are appointed by the board, my lord, the subsequently we have been retained, my lord. Because in the appointment letter, my lord, copy has been served to the government, my lord. It is not about government, not unaware, my lord. Copy is our deputy secretary, government of Assam.
One question which has been raised on behalf of the department, one basic question, that at the time of induction into the services,
Yes.
were you given any expectation or assurance or something that your services will be pensionable service? Number one, that
Yes.
we do not find from the materials.
Yes.
Number two, even if that is not expressly made known to you, then you have to make out a case that the rules or the law holding the field would make you entitled for making such a claim. You are taking recourse to 31.
Yes.
31 reading per se may not mean that you are under the government. You're trying to bring in 31 by saying the retention has been done by the
Yes, ma'am.
government and that too permanent retention.
Yes.
Payment of salaries is by the government, maybe by grant.
Gandhi,
aids,
my lord.
but it is through the government, and the director himself is on deputation.
Yes.
He's an officer
Yes.
of the state. See, by that, what Madam Datta has placed on record, the case of 2009 5 SCC.
Admittedly, my lord, I know, my lord, the Orissa Khadi board, my lord, is against me, my lord.
No, see, bringing the respondent within the meaning of Article 12
Yes.
is a different aspect altogether. If some actions were taken, which is not allowed to be taken by a state,
Yes.
then we can still assign the meaning of state to such an organization. For maybe for some disciplinary action or some scheme
Yes.
which is not reasonable,
Yes.
which maybe some private employer may take, but it is not, you cannot take as a body which has been run
Yes.
by the government. But so far as the finance is concerned, those are internal matters.
Yes.
Can we equate the society with the department? And this was a case where it was also of a cooperative society, and the Honorable Supreme Court has also taken into account the Steel Authority case, which was dealing with a public sector undertaking.
But the Orissa Khadi board also, my lord, is against me, my lord.
Okay. People, label at the bottom of the march. No problem.
In the Orissa Khadi board, but the Supreme Court said, but I don't know, I've gone from, my lord. It's up to me, my lord.
Can you give the citation?
It's in live law, my lord.
I don't think it's reported. Is it reported?
Just pass on. Instead of Odisha Bhasha, Odisha Khadi and Village Industry Board.
Well, is it reported?
Why it's not, I have to see, man. What is it?
এখন বন্ধ কৰি দিয়া আছে, পিছত দিব বাৰু ফোনখন।
Sir, mail to stop.
পিছত লাগিলে দিম।
Huh?
Okay.
I sent from mail.
Well. Seven numbers of petitioners have joined together in this petition, which had been filed primarily with a claim for pensionary benefits. pensionary and other post-retirement benefits as per the Assam pension. Assam services within bracket pension, bracket close rules 1969, within bracket hereinafter called the rules. Full stop para. The facts as projected in the petition is that the petitioners are that is not our facts question are that the petitioners were appointed as grade 3 and grade 4 employees in the Assam Minority Development Board. Full stop. The board was constituted in the year which was constituted in the year 1985. No, actually, a board which was constituted in the year 1985. At a line of division. Full stop. The a certain post for the said board were sanctioned by orders dated 28 to 1987 and 29/12/1987. Full stop. It is contended that the posts are sanctioned posts. Full stop. Wide an order dated 25/1/2012, the department had permanently retained the said post pursuant to which pursuant to his post. Full stop. Subsequently, the GPF accounts of the petitioners were opened on 6/12/2012. Full stop. Thereafter, the director of the board had issued a communication dated 25/4/2013 to the department towards regularization of the towards payment of pensionary towards payment of pension to the petitioners. Full stop. The said communication was, however, negated by the department wide letter dated 22/2/2012 by stating that the board was registered under the Societies Registration Act, and accordingly the petitioners are not entitled to the pensionary benefits. Full stop. Subsequently, by communication dated 19/7/2013, the department had informed the director of the board that the employees would not fall under the rules of 1969. Full stop. Para. I have heard Sri S. Bothakur, learned counsel for the petitioners. Full stop. I have also heard Miss M.D. Bora, the learned standing counsel. What is the name?
Department, Welfare of Minorities Development Department.
Welfare of Minorities Development Department, and Sri S.K. Medhi, learned standing counsel, AG Assam. Okay. Full stop. Sri C.S. Hazarika, learned state council, is present for the other state respondents. Full stop. Para. Sri Bothakur, the learned counsel for the petitioners, by referring to Rule 31 of the rules of 1969, has submitted that 3 conditions are laid down by the said rule as qualification for pension. Full stop. He submits that the petitioners fulfill the aforesaid conditions in view of the fact that the board is wholly controlled by the government, and for all practical purposes, the petitioners can be treated as government servants, full stop. It is further submitted that the salaries of the petitioners are paid from the government funds and the posts are permanently retained by the department. Full stop. The Learned Council has also taken the aid of Rule 36, which lays down that continuous temporary or officiating service can also be included for the purpose of pension. Full stop. It is submitted that for all practical purposes, comma, the posts in question are under the department, and even the director of the board is an ACS officer who is paid salary by the government. Full stop. Para. In support of his submission, comma, the Learned Council has relied upon the decision of this court reported in 2004 3 GLR 211 within bracket Pulin Goswami versus State of Assam. Full stop. In the said case, comma, a direction was given by this court for release of pensionary benefits to the incumbent in that case who was working as a teacher against a duly sanctioned post. Full stop. Para. Per contra, comma, Ms. Bora, the Learned Standing Council of the concerned department has strenuously opposed the writ petition. Full stop. It is submitted that the petitioners are not government employees, and the order dated 25/1/2012 of permanent retention would itself make it clear that the salaries were paid from as a grant in aid and not from the normal head of salaries. H2 capital করবে না? Full stop. The department wide communication dated 19/7/2013 after examination of the matter had made it clear that the services of the petitioners would not come within the ambit of the rules of 1969. Full stop. By drawing the attention of this court to the affidavit in opposition filed on 23/2014, comma, the Learned Standing Council has placed on record the averments made therein, comma, more specifically in paragraphs 4 and 7, wherein, full stop, 7, full stop, in the said paragraphs, comma, the aspect of payment of salaries from grant as a form of granting aid, and and the aspect that permanent retention would not mean eligibility to pension have been clearly stated. Full stop. Para. The Learned Standing Council has also relied upon the case of State of Assam versus Barak Valley so and so, reported in 2009, 5 SCC 694, full stop. It is submitted that in the aforesaid decision, comma, the Honorable Supreme Court has carved out a distinction between the aspect of holding a respondent to be a state within the meaning of Article 12 of the Constitution of India, and the aspect of financial burden to be cast upon such a body. Full stop. Para. 3. S.K. Medhi, Learned Standing Council, AG, while endorsing the submission of the Learned Standing Council of the department, has submitted that Rule 31 of the Rules of 1969 would not has submitted that the petitioners cannot be held to have fulfilled the conditions laid down in Rule 31 of the Rules of 1969 to claim pensionary benefits. Full stop. 3. Hazarika, the Learned State Council, also endorses the aforesaid views of the department. Full stop. He also submits that the state cannot be burdened with financial, cannot be financially burdened in as much as the initial entry of the petitioners in their service was not with any such condition of payment of pension. Full stop. Para. The rival submissions and the materials based duly considered. Para. The grounds on which the present claim is based, comma, as projected, as contended, is that the posts were sanctioned posts and which were permanently retained. Full stop. It is also contended that for all practical purposes, comma, the board has to be construed to be a state within the meaning of Article 12 of the Constitution of India. Full stop. The permanent nature of the services rendered would also be a relevant factor towards consideration of the claim. Full stop. Para. The first contention that the posts are sanctioned government post is not substantiated with the records, with the materials placed on record, full stop. No doubt, comma, the posts were permanently retained, comma, and the same were sanctioned by the order dated 28 to 1987, comma. Such sanction was only with respect to the functioning of the board, full stop. It is not in dispute that the board is a society registered under the Registration of Societies Act 19. Where have you made this statement?
I have my active.
Is a society registered under the Societies Registration Act, comma 1960. Full stop. This court has also noticed that though the posts were permanently retained, comma, there is a stipulation that the salaries to the employees, within bracket petitioners, were to be paid from the grant in aid and not under the ordinary head of salaries. Full stop. The grievance is not with regard to any aspect of not making such grants in aid available, whereby the salaries and other aspects have not been able to be released to the petitioner, full stop. The grievance, comma, as observed above, is towards the pensionary benefits, full stop. This court has also been informed that out of the 7 numbers of petitioners, comma, petitioner number 6 and 7 have superannuated after attaining have retired from service after attaining the age of superannuation. Full stop. The contention that the board in question is to be treated as to come within the ambit of state as capital under the meaning of Article 12 of the Constitution of India may be relevant for many aspects towards this functioning vis-a-vis the employees, full stop. However, the said aspect cannot be stretched to the issue of payment of pensionary benefits, full stop. This court has also taken into consideration that there has been the consideration that nothing has been placed on record that at the time of induction into the services, comma, any such condition or expectation, any such condition was attached or stipulated, or any expectation given that the petitioners would be paid pensionary benefits, would be given pensionary benefits, full stop. Para, on a specific query, comma, the learned counsel for the petitioners have fairly submitted that certain benefits, certain post-retirement benefits are given to the employees, but not pension under the rules of 1969, full stop. Para, the aforesaid aspect of the matter has been put to rest by the Honorable Supreme Court in the case of Barak Upattaka Supra. In the aforesaid case, the Honorable Supreme Court was considering the demand of the employee of Kachar and Karimganj District Milk Producers Cooperative Union Limited, within brackets Kamul. Full stop. Though the Honorable Supreme Court had come to a conclusion that in view of the nature of the control of the government over the cooperative, over the society, would bring it within the ambit of Article 12, that by itself may bring it. That by itself would not be enough to pass a direction for payment of salaries and other dues to the employees by such employees by the state government, full stop. For ready reference, the relevant portion of the judgment is extracted here in below. 9, 11, 23 and 24, full stop. This court has also taken the aid of a recent decision of the Honorable Supreme Court in the case of State of Orissa and another versus Orissa Khadi Swensu, passed in civil appeal number 6944/2015, wide judgment and order dated 17/3/2023. Full stop. It is held that
it says our service cannot be at par with the regular.
it is held that employees of the board in question, namely the Orissa Khadi and Village Industries Board, cannot be held to be at par with government employees and therefore not entitled to pension, full stop. It is noteworthy that the Honorable Supreme Court has also gone to the extent of observing that such powers cannot be exercised even by taking into recourse Article 142, as the same would be beyond, as the same would be contrary to the law. Full stop. Para. As regards the case of Pulin Goswami cited by the petitioner, the facts are distinguishable in as much as, the petitioner in that case was working as a teacher against a duly sanctioned post continuously, and only because the services were under the KAAC under the Karbi Anglong Autonomous Council, comma, such pensionary benefits could not have been denied to him, full stop. It may be mentioned that the KAAC is created under the sixth schedule of the Constitution of India. Unlike the present society, unlike the present board, which is a society under the Societies Registration Act, full stop. In view of the aforesaid discussion, comma, this court is of the considered opinion that no case for interference is made out, and accordingly, the writ petition stands dismissed. Hmm. Yes.
Well, in this case, the petitioner, who is no longer in service, challenges his termination at Annexure 23, madam. Page 82.
Mr. Bora, for whom? Health Department.
For the Health Department.
Health Department, my lord, the petitioner was under the Karbi Anglong Autonomous Council, my lord.
You are there, KAC, okay. Yes,
And the disciplinary proceeding was conducted by the Health Department.
it's a DP.
Yes, madam.
There were two DPs, my lord.
Termination.
Termination is in the second DP.
You are working as what?
Doctor, my lord, MBBS doctor,
Okay.
government.
What is your age now?
My age, my lord. My age is, my lord, almost due to retirement, my lord.
So, at most you will get some emotional benefits.
Yes, my lord.
What are you doing now? Private practice?
My lord, I think so, my lord.
Okay. Please, yes. Can briefly state the facts?
Yes, my lord. My lord, first of all, my lord, I'll just read out my order of removal, my lord, and then I'll come to the fact. Page 82. Order dated 30th of July 2018, my lord.
82.
Page 82, my lord, Annexure 23.
82.
My lord, prior to this, earlier, my lord, there was one DP in which he was reinstated after suspension, my lord. And thereafter, my lord, this second DP was drawn up, and then this order. As your lordship.
Yes,
Yes, my lord.
3718.
Yes, my lord. My lord, initially the materials which were before the authority have been listed, and then, my lord, findings, my lord, I'm reading the findings. Whereas
Yes.
Dr. Pradeep Kumar Dev Mahanta was placed under suspension by order number HLS so dated 16/3/1989. And whereas Dr. Pradeep Kumar Dev Mahanta was reinstated into service without prejudice to departmental proceeding by order number HLA dated 5/7/2000 and posted at Bukajan AHC, Karbi Anglong. Dr. Pradeep Kumar Dev Mahanta reported for duty on 31/07/2000. Accordingly, which was accepted by the Secretary Karbi Anglong Autonomous Council, but he didn't take over charges and remained continuously absent from duty from the date of joining without any information to the authority. And whereas Dr. Pradeep Kumar Dev Mahanta was asked to explain for such unauthorized absence and negligence of duty within 7 days by number so-and-so dated 23/2/2006, but Dr. Mahanta did not submit reply in compliance of government order. And whereas show cause notice on the charges of gross negligence of duty and unauthorized absence for a long time was issued by order number so-and-so dated 2012, and subsequently Dr. Mohanta submitted his reply by letter dated 12/2/2013, wherein he denied all the allegations raised against him, and whereas the inquiry officer, the then Undersecretary Sri S.N. Pathak Health and Family Welfare Department submitted the inquiry report, and whereas after careful perusal and going through the inquiry report and findings submitted by the inquiry officer, supported by relevant records or documents, it appears that the charges of unauthorized absence and willful negligence of duty by Dr. P.K. Deb Mohanta has been established, which is fully attributable to him. And whereas Dr. Pradeep Kumar Deb Mohanta remained unauthorizedly absent with effect from 31/7/2000, and whereas it is also evident from the report of the inquiry officer of the departmental proceeding and replies submitted by Dr. Mohanta during the inquiry that Dr. Mohanta did not take any serious steps to intimate the authorities and the government during such long period of absence from service for resuming his duty. Therefore, in view of the inquiry report and examination of the show cause reply, the Governor of Assam is pleased to remove the Dr. Pradeep Kumar Deb Mohanta from service as per provisions under Rule 7(6) of the Assam Service Discipline and Appeal Rules 1964. My lord, this is dated, as your lordship has noted, 30th of July 2018. My lord. I say, my lord, this order is without basis, my lord, and they had relied on their presumptions, my lord, as if, my lord, they had no responsibility towards, my lord, posting him, posting the officer, my lord, the petitioner, so that he could join. Now, my lord, the facts. In short, my lord, I will be as short as possible, my lord. My lord, the petitioner was working at the MMC Hospital, Guwahati, initially after joining here, my lord, at the relevant time. Page 31 may kindly be seen, my lord, when this DP was drawn up against him, my lord. DP 1, my lord. কাগজ কখন দিয়া থেকে দি দি এখন দি C1 DP 2 যাচ্ছে তো page 31, my lord. This is the order dated 5th of July 2000. Without prejudice to the departmental proceeding and in the interest of public service, Dr. P.K. Deb Mohanta, MNHO 1, MMC Hospital Guwahati, who was placed on suspension by so is hereby reinstated in service with immediate effect. On his reinstatement, Dr. P.K. Deb Mohanta, MMC, in the interest of public, is hereby posted at Bokajan CHC. This is important, my lord. Karbi Anglong against the vacant post of MNHO 1 with immediate effect. My lord, next is my joining letter submitted at Bokajan. Under intimation to the Undersecretary Government of Assam, Health and Family Dispur, Guwahati. This is dated 31/7/2000 at next page. With reference to above, I hereby submit my joining report and the same may kindly be accepted. This is addressed to Joint Directorate of Health Service, Karbi Anglong Autonomous Council, Karbi Anglong Difu, my lord. With reference to the order dated 5/7/2000.
Yes, sir.
Your lordship will see the exact copy, my lord, which also bear a, my lord, receipt signature, my lord.
Okay.
Next page, my 33. Now, my lord, what has happened is this, my lord, the facts are like this, my lord. He has submitted the joining report, my lord, and the officer concerned who was present there, my lord, he refused to accept that, saying that there was no intimation to him, so therefore he cannot hand over the charge. So that was the issue, my lord, which prevented me from discharging my service, my lord. And it went on and on, my lord.
Now, what is this then? What is
My lord?
page 34?
Yes, my lord. Now page 34, your lordship will kindly come. So this continued, my lord. I was not there, man. This was an order passed by the ultimately Secretary, Health and Family Welfare, Karbi Anglong Autonomous Council, Difu.
Yes.
In the interest of public service, the authority of the Karbi Anglong Autonomous Council is pleased to accept the joining report of Dr. Pradeep Kumar Deb Mohanta, Bokajan CHC against vacant post of MNHO 1, white government notified number so and so. His date of joining dated 31/7 is accepted. Now your lordship will kindly note the date. This is dated 11/1/2001.
Yes.
But apparently it was signed on 8/7 because that at below at bottom, my lord, memo number and date 8/7/2001. So there was something that was holding them back, my lord. And all along, my lord, they were trying to put the blame on me, my lord. I am saying, my lord, you give me a posting anywhere, my lord. Why Bokazan, my lord? They
But that
didn't
is-
do it.
that-
Even this, they had after 1 year, my lord. It means,
That is not 11-1.
my lord, this 8/7/2001 is, it means, my lord, they accepted my joining at Bokazan or after a period of 1 year.
Eight, 7,000. The original one is in the next. Page. Not 1,001.
It is 81, 81, even when, no, see.
And affidavit.
Affidavit to be made, record to police program. You have to pay 1 5. There's overtyping. What is this? This is 2001. Couldn't have been 2000. Now, my lord, when no order of posting was assigned to me, my lord, except, my lord, they had accepted the joining date, my joining, but no posting was assigned. I had to come before this court, my lord. That is at page 36, my lord. This is an order passed after hearing all the parties, my lord. The relevant directions are at page 38. May I read, my lord? At page 38.
Yes.
The para at the bottom, my lord.
Yeah.
The pendency of the departmental proceeding against the writ petitioner initiated as far back as in 1989 reflects a highly unsatisfactory state of affairs, my lord. However, as the said question is not in issue in the present writ petition, the court restrains itself from making any observation on the said aspect of the matter. However, having regard to the totality of the facts of the case, this writ petition will now stand finally decided with the direction that the respondent number 1, namely Commissioner and Secretary to the Government of Assam Health Department, shall take all necessary steps to finally conclude the departmental proceeding against the writ petitioner, including the passing of the final order by the disciplinary authority within 45 days from the date of receipt of the certified copy of this order. If the petitioner continues to feel aggrieved by the order which may be passed by the disciplinary authority pursuant here, it will be open for him to seek all such remedies as may be open to him in law. As regards the other reliefs claimed in the writ petition, namely to permit the writ petitioner to join and function at his new place of posting, this court hereby directs respondents 2 and 3, namely Karbi Anglong Autonomous Council and in charge Bokazan Public Health Centers to pass necessary order within 7 days from the date of receipt of the certified copy of this order to enable the petitioner to start performing his duties as medical and health officer 1 in the Bokazan Public Health Center, Bokazan. Respond number 2 and 3 shall also pay to the writ petitioner his salary and allowance as may be consequent. This now, my lord, was never carried out. This direction, my lord. This never happened, my lord. And this order was passed after hearing all the parties, my lord, who are relevant to the issue. Now, page 44, my lord. That is the order passed on 20th of January 2004, whereby, my lord, the first DP was closed, which was drawn up in Panbazar, my lord. May I read, my lord? The allegations and charges leveled against Dr. Pradip Kumar Dev Mohanto, the then MNHO1 of Mahendra Mohan Chaudhary Hospital, Guwahati, Kamrup. Your lordship will kindly note, my lord, this was initiated in the year 1989. The inquiry report submitted by the then Joint Secretary to the Government of Assam Health and Family Welfare Department, along with the statement in defense submitted by Dr. Pradip Kumar Dev Mohanto and the statements recorded from different witnesses. On perusal and going through the records of the case, the charges and statement of allegations leveled against Dr. P.K. Dev Mohanto, and after careful consideration of the facts and circumstances of the departmental proceeding drawn against him, the disciplinary authority is satisfied that the charge number 1 and 2 is difficult to substantiate but the charge number 3 have been proved, as Dr. Mohanto had admitted that he performed 7 MTP.
We
Uh,
have read this, stoppage of promotion for 3 years.
Yes, my lord, ultimately, my lord. But your lordship will kindly note, the governor of Assam is further pleased to order that the period of suspension will be treated as on duty for all terms.
Yes.
Now, this is for the purpose of my lord. During the period of my suspension, I was paid, my lord, the subsistence allowance to the extent of 75%. The rest 25% has not been paid till date. Other issues apart, man. The subsistence allowance, even, my lord, which is admitted by them, has not been paid to me till date.
No, see, there are simply by an observation that your suspension period will be treated on duty may not mean that you are entitled to the full salary. It is up to the department to pass.
They have not passed any order. my-
This observation will only ensure that there is no break in your service.
Yes, my lord.
But it has to be followed necessarily by an order, how much salaries they are going to pay or whether they are not going to pay any salary. See, this
Yes,
is
my
a-
lord, that has not
so
been
this is
passed by-
not a closure of a DP that you have been held, the services are held to be unsubstantiated. There is a penalty prescribed and imposed. Thereafter, observation has been made that suspension period will be held in duty
As of
only
today.
because of the break.
So that period is regularized.
Regularized.
Yes, my lord. If that is regularized, they have-
Whether you can definitely make a claim for your full salary.
Yes, ma'am.
That will consider, but that will not be an automatic conclusion.
my lord.
Okay.
But it is, my lord, within their, my lord, limits to pass that order, my lord. I cannot do anything, my lord. They have not passed any order till date.
Okay.
Now, my lord,
What is your grievance and what are your grounds of challenge now
my lord,
towards
my
the
lord, now-
grievance of removal of your
my lord, removal is without any basis, my lord. Removal is, my lord, because of what absenteeism and negligence, my lord. Why absenteeism, negligence? Because there is no posting order, my lord. Where I can go?
Bukajan?
Bukajan, I have gone, my lord. They didn't accept. They didn't hand over charge, man.
After the order of
Order also, even thereafter. Even thereafter, man.
where have you stated?
I have stated. The para 4, my lord. I think elsewhere also I have stated, my lord, para 4. It is not being able to take over charge as MNHO 1 at Bukadan. Directly approach the office of the Joint DHS Karbi Anglong Diffu, but strangely no action was taken by the said office and the petitioner was forced to run from pillar to post for quite some time till that order, my lord, which I have shown, my lord, 8/7/2001 by Secretary Health and Family of Karbi Anglong, accepting the joining report of the petitioner dated so and so at Bukadan, by government notification number dated Iman, and further specifically accepting his date of joining as 31/7/2000. That the petitioner states that while he tried his best to take over charge at Bukadan PH, it was not handed over the charge, and in fact, even with the aforesaid order dated 8/7/2000, the petitioner was not allowed to take over as MNHO 1 at Bukadan by the then MNHO 1 ICDR. The clout of the petitioner, particular officer serving as so and so, can be understood by the amount of his influence over the power that we, which is clearly evident from the time gap between the date of passing 11/1/2001 and issuing 8/7/2001 of the aforesaid order dated 8/7/2001. Being agreed with the aforesaid action of the respondent not being able to function as also not receiving salary for a long time, petitioner had to come to the file that petitioner. Well, even the direction of the court was also not carried out by them, which was an order passed by after hearing all the parties. And thereafter, my lord, at annexure 6 is representation from my side, my lord.
How have you verified your paragraphs 3 and 4?
My lord.
How have you verified paragraphs 3 and 4? That you are not allowed to join?
Well, it is for them, my record. We are
No,
called
no,
for,
no.
my
How
lord.
have you verified? You have
My
not
lord.
allowed to be, you are not allowed to join. That is your allegation.
My lord.
How have you verified? I go there, I am not allowed to join. Is it
Right.
a matter of record?
Well, that, my lord, your lordship has to find out from records, my
No,
lord,
no, why
whatever.
should we find out? It's your allegation. If you
My
go to a
lord, in that
place,
order, my lord,
no,
that
we are
subse-
not on the order, we are on the allegation that you go to a place, you are not allowed to.
my lord, even my, your lordship will kindly see the order, this dated 8/7/2001. my lord, 8/7/2001, and in the High Court, my lord, they are the submissions, my lord. Let us see the submissions from them, my lord, the High Court order, my lord. My lord, if they had anything against me, my lord, they should have placed it.
No, High Court's order is of 2002.
Yes, my lord. After I was put there,
Yes.
it was fine in the aftermath of my submitting the joining report.
To complete the DP and
Yes,
to
my lord.
allow petitioner to join.
Yes, my lord. The joining direction is there, my lord.
Yes.
Meaning thereby that yes, they didn't allow me to join, my lord. There is
No,
no
after this direction, where is your averment after post 2000, post 6 to 2002?
post thick, my lord. My lord, I had all along been representing, I am saying that, my lord. That is my case, my lord. You post me anywhere, because
No, no, where?
my lord, I'll say that. My lord. This is before that 2002, my lord.
No, after the 2002.
Yes,
post.
yes. My lord, at para 6 also I had said, my lord.
Para 6 is what? We have read para 6.
Para 6 of my writ petition.
We have read para 6.
6 I have not read. That the petitioner obtained certified copy of the
We
aforesaid
have
order.
read this.
Yes, my lord. Needless to say that the respondent did not comply with the order keeping
Not
sign.
enough.
My lord.
Not enough.
Yes, my lord. Para 8. Para 8, my lord. Page 8. That the petitioner naturally became aggrieved with the aforesaid order dated 21/2004 from the disciplinary and submitted a written representation against the same on 16/2004. Inter alia stating therein that he was neither allowed to join in his transferred place of posting, nor was there any order passed by the Karbi Anglong Autonomous District Authority as directed by the Honorable High Court within 7 days from the date of order of the court dated so and so, enabling the petitioner to start performing his duties as MNHO1 at Bukadam. And that without having any specific order, he had no place of posting to take charges. This is my reply.
Where is the representation?
On my representation.
46.
May I read, my lord?
The 6.
That I was not being allowed to join in my service. Address to the Secretary to the Government of Assam, Health and Family. I was not being allowed to join in my service and no order was passed by the respondent number 2 and 3 as mentioned in WPC 72401 before the Honorable Guwahati High Court, the order of which was passed on 6/2/2002. The order states, amongst others, my lord, it quoted from there. I'm just keeping it, my lord. That without having any specific order, I will have no place of posting to join. That no salary and allowance were paid to me as per order of Honorable Guwahati High Court in WPC number 740/2001, wherein it was stated that respondent number 2 and 3 shall also pay to the writ petitioner his salary and allowances as may be consequential to the revocation of the order of suspension. That a departmental proceeding which was initiated as far back as 1989 was completed as per order dated 21/04, wherein the disciplinary authority implicated me in charge number 3 for non-production of hospital record by the hospital authority. The disciplinary authority recommended for my punishment in the form of stoppage of promotion to next higher rank for 3 years. That the departmental proceeding was to be completed within 45 days of passing of order of Honorable Guwahati High Court on 6/2/02, which amounts to contempt of court order at the cost of my professional, financial, and social life in gross violation of law of natural justice. The said order of the court states that, however, having regard to the totality of the facts of the case, this writ petition will now stand finally decided with the direction in respondent number 1, namely, Commissioner and Secretary to the Government of Assam Health Department shall take all necessary steps to finally conclude the department proceeding against the writ petitioner, including passing of the final order by the disciplinary authority within 45 days from the date of receipt of the certified copy of this order. The disciplinary authority did impose on me punishment for fault of hospital authority and without giving me any chance for clarification. That is unjustified to impose penalty on the part of disciplinary authority in clear violation of the order of Honorable Guwahati High Court, by which the final order of disciplinary authority should have been passed somewhere in the month of April 2002. That I still have the necessary photocopy of the records of minor OT of MMC hospital of the said period, for example, 19, to prove my innocence, and also to show that the disciplinary authority has not gone into details of the case. That's why in the above corner, I would like to pray for your good self to pass an order for my place of posting and to release my payment. To pass necessary orders for revocation of impugn order or punishment passed against me, showing at least minimum respect for justice after long 15 years of disciplinary proceeding in violation of order of Honorable Guwahati High Court, etc. etc. Now, this was sent under registered postman. And also then, my lord, there was a show person. Annexus 7. Page 48. From the government. In inviting reference to this department's notification cited above, I am directed to say.
Yes,
Page 48.
yes, we have read.
In inviting reference to this department's notification cited, I am directed to say that it is reported by the joint that you reported for joining us against Lokazan, but did not take over charge. Further, you remaining absent from duty since date of reporting without authority. You are therefore requested to submit explanation on the above why disciplinary action should not be initiated against you for your unauthorized absence and negligence of duty. Your written reply on the above should reach the undersigned within 7 days without pay. That was replied to, my lord. This is dated 1/6/2006, my lord. My letter, Annexure 8. At para 3, my lord, in the document at page 49, para 3, may kindly be seen. Finding no other, I have specifically stated, no other alternative, I have reported to Joint Directorate of Health Service, Karbi Anglong on 31 for my joining, who took another 5 months to pass an order, the 11/1/2001. Actually, it was passed after 1 year, man, 8/7/2001. And after personally collecting the order, I went to Bukazan to join in my service. The in-charge of the said hospital refused to permit me to join in the hospital on the ground that they have got no order from the joint DHS in this regard, madam. I could not have been more specific than this, madam.
No, that was the,
Yes.
that was the condition or situation which existed at that time.
Yes, madam.
You are writing this in 2006.
My lord.
2006, you say in paragraph 6 that I prayed to the secretary in 2004 requesting for orders. But this was already, you are giving this as an explanation to a communication of 2006. When did you go to Bukazan?
At all relevant point of time, my
No,
lord.
no, where
Because
is
my
it?
para 8 is clear.
No, that you had gone prior to the.
No, para 8 is after 2002.
Paragraph 8.
Yes, yes,
Please
madam.
read.
Page 8, it will be
Yes,
page.
yes.
That the petitioner naturally became aggrieved with the aforesaid order dated 21/2004 from the disciplinary authority and submitted a written representation against the same on 16/2004 entirely stating therein.
He was neither allowed to join. That is a version in your written statement.
Yes, madam. As directed by the Honorable High Court within 7 days from this point, so enabling the petitioner start performing duties at Bukazan, that without having any specific order, he had no place of posting to take charge.
Yes. Okay. Yes,
Well,
Mr. Bora.
Then, my lord, I filed, my lord, application RTI. This went on and on and on, my lord. Then ultimately, my lord, there was another letter in the year 2012, my lord, Annexure 11, page 54. It's a show cause to me, my lord.
Yes.
Page 54.
Yes, what is 54?
My lord, the second paragraph I'm reading, my lord. You reported to a duty on 31/7/2000 accordingly, which was also accepted by Secretary KAC, but you did not take over charge and remained continuously absent from duty from the date of joining without any involved authority. Secondly, you were asked to explain for such unauthorized absence and negligence of duty within 7 days, right? HLS, but you did not submit your reply in compliance of government order. And then, my lord, this statement of allegations annexed to it. No separate order for charge was passed. And my lord, then reply to so-called notice dated 7/3/2012 from my side. Second DP was started thereafter, my lord. At page 59, my lord, reference, I am directed to say that the date of hearing of the departmental proceeding drawn up against you is fixed on 13/5/13 at 12 noon in the chamber of the undersigned. From the undersecretary. On 16/12/2014, next, my lord, page 16, forwarding of inquiry report in respect to DP drawn up against your representative thereon. If any, I am directed to refer to subject mentioned above and forward herewith copy of inquiry report. I have made a statement, my lord, at page 67, my lord, because I received this only on, though it is dated 16/12/2014, I received it on 4/4/2015. That statement is at page 67. Page 60, huh? Para 67. Okay. What is it? Yes, my page 67, my lord, this is my subsequent representation, wherein I have stated, my lord, that I would like to inform you that I have received the inquiry report 16/5/14 along with the letter by HLA dated 16/12/14 only on 4/4/15. So that is 4 months thereafter. Accordingly, I submit my reply as here and I replied to them nonetheless. So there was some sort of a lethargy, my lord, against this petitioner, my lord. The records have been called for, your lordship will see, my lord. Why these things have happened in spite of the direction from the court, in spite of the effort made by the petitioner himself, my lord. Hmm? 70? Now, my lord, the DP was started and it went on and on and on. So thereafter, I again had to approach this court, which I did in 2016, my lord. An order was passed in this order on 21/4/2017, page 76, 77, my lord. And it was closed, my lord, after hearing the parties at page 77. I'm reading out. Having heard the learned counsel and also considering the submissions made, this writ petition is disposed of with direction to the respond number 1 to bring the disciplinary proceeding to its logical conclusion by passing a final order within an outer limit period of 3 weeks from today. A copy
Okay, I
of
will come back.
my lord.
Yes, how long will you take?
My lord, 15-20 minutes, my lord. And then Karbi Anglong, because they will have to.
আজি কেইটাত উঠিব লাগিব 3:15 দেৰিকে বহিব লাগিব আজি 2:30 বহি এইটো পাহৰণে নাই নাজানো এইটো কৰিলে we'll sit at 2:30. There is some personal
My lord,
okay,
my lord.
come at 2:30.
Lord, I order dated 5/7/2000, my lord, at Annexure 1, page 31, my lord. The petitioner, my lord, from
Page 31.
page 31, Annexure 1, my lord, of the writ petition, my lord.
Just a minute, please. Yes.
My lord, the petitioner went to his new place of posting, and my lord, he just submit the joining report. And thereafter, he never went there, my lord. Because search handing over, search taking over, that formalities also he did not complete, my lord. And my lord, as alleged by the petitioner that if he was not allowed to hand over and take over search, my lord, he should have approached the concerned joint director of health service, my lord. But he never contacted
Just a
them.
minute, please. Yes.
So he never contacted the concerned higher authority, my lord, joint director of health service.
Mm.
And as regard the, my lord, after passing of the order dated 21/2004, in terms of the order passed by this honorable court, my lord, in writ petition number 7240 of 2001, my lord, and at annexure 44, my lord, this is a order passed pursuant to the closure of the disciplinary proceeding, my lord. So in this order, my lord, already the petitioner annexure 5, my lord.
Page 44.
Page 44, my lord. The petitioner, my lord, already has been reinstated in service by annexure 1 order dated 5/7/2000. He has been given a place of posting, my lord. So by this order, after closure of the disciplinary proceeding, my lord, there was no requirement of giving a new place of posting, my lord. Because while he was reinstated, my lord, at that point of time, he was posted at a new place of posting at Pukadan Civil Hospital, my lord. So by annexure 5, my lord, there was no requirement to give a new place of posting to the petitioner, my lord. Because already he was posted at, my lord, Pukadan Civil Hospital, Karbi Anglong, my lord. And as the petitioner has relied upon the annexure 6, page 46, my lord, his representation, my lord, page 46, annexure 6.
Yes.
His representation at clause 2, my lord, he has written that without having any specific order, I will have no place of posting to join. My lord, why there is he requires a specific order to that effect? Already he has been reinstated and posted at Bukadan Civil Hospital. Subsequently, by this order dated 21/2004, my lord, the disciplinary proceeding has been closed by imposing a minor penalty, my lord. So in this order, why there should be a place of posting, my lord? Because already he is there, my lord. Upon his reinstatement, he is serving in one place. He was posted in one place, my lord. So, my lord, in the meantime, the joint director of Karbi Anglong Autonomous Council, my lord, reported the matter of his unauthorized absence to the government, my lord. Accordingly, government by annexure 7, page 48, my lord, issued a explanation, issued a letter thereby calling for explanation to the petitioner, my lord. Annexure 7, page 48, right, letter dated 24/2006, my lord. In inviting reference to this department notification cited above, I am directed to say that it is reported by the Joint Director of Health Service, Karbi Anglong, that you reported for joining as medical and health officer against Pukadan PHC on 31/7/2000, but did not take over search. Further, you remaining absent from duty since the date of reporting without authority. You are therefore requested to submit explanation on the above why disciplinary action should not be initiated against you for your unauthorized absence. My lord, in response to this letter, my lord, the petitioner did not submit any reply, my lord. The next page, my lord, page 49, annexure 8, the petitioner has contending that he has filed a response to this notice, my lord. This is letter dated 1/6/2006, my lord. But from perusal of this letter, your lordship will find that it is not in response to that so-called notice, my lord. That explanation letter was dated 24/2006, my lord. And petitioner submitted this letter in the form of a representation, my lord, on 1/6/2006. And here also, my lord, in the subject or anywhere else, my lord, there is no reference to the so-called notice, explanation letter, my lord. So, my lord, apparently, my lord, when explanation letter was issued to the petitioner asking him to explain the reason for his unauthorized absence, my lord, he has not responded it and he has not filed any reply, my lord. Indicating that, my lord, as a matter of fact, my lord, when the petitioner was in Guwahati, he has been transferred to Bukaz and there is no private practice there, all, my lord. So he did not go there and started his duty there. Only once he went there, just joined and came back, my lord. Thereafter, he did not go there, my lord. So thereafter, disciplinary proceeding was initiated, my lord. And in the disciplinary proceeding, my lord, I have got the entire record statement of witnesses also. In the disciplinary proceeding, it has been established that he has been unauthorizedly absent from his duties, my lord, since the year 2000, my lord. Accordingly, the major penalty of removal from service has been imposed upon. All along, my lord, the petitioner is intentionally, my lord, absent from his duty, my lord. There was no lapses on the part of the government or the Karbi Anglong Autonomous Council, my lord. Because, my lord, government issued a transparent posting order. Karbi Anglong Autonomous Council accepted it, and to that effect, they passed an order, my lord. Thereafter, there is no any barrier or bar for the petitioner to perform duty over there, my lord. But he unauthorizedly absent, and to this proposed notice dated 24/2006 also, my lord, he did not respond, my lord. And if your lordship wants that, I can produce the record also, my lord, of the disciplinary proceeding, my lord. My record is regarding the disciplinary proceeding only. And regarding the unauthorized absence or other thing, my lord, my learned pen will produce.
Yes,
Obligation.
Mr. Borwa for?
For accountant general record here.
You don't have much of a role.
I know,
actually.
but anyhow, I have to submit one paragraph, which against me also.
Okay.
That is why, particularly paragraph, which your lordship, 24 of petition regarding payment of 25 something allowance and another area thing. To that effect, we have filed a short affidavit. The affidavit was filed on Miller, 14th day of December 2020. It is run by Srimati Dr. Nirmala Mati mentioned. Here we have clearly stated, because we did just to come up with the allegation with me. So, my thought there. That with regard to the statement made in paragraph 24 of the petition, the humble deponent begs to state that the authority for drawing area paid allowance, including the remaining 25% of such an allowance, shall be authorized from this end, that is from the AG, only on receipt of clear instruction from the Health and Family Welfare Department. The accumulated account of GPF will be released on receipt of formal application from the petitioner duly routed through the Deputy Secretary to the Governor of Assam Health and Family Welfare Department. It may be pertinent to mention that by letter, that the petitioner is terminated from his service by the order dated, that is annexed 23/37/2018, Miller, Dr. Valery Governor, and by the Government of Assam Health and Family Welfare Department, but the state order did not mention effective date of termination. Therefore, this office requires specific instruction for the government institution, ADRP, and allowances. Because GPF we cannot hold. Because whatever amount is be there, we have to pay. But this is the criteria. Now, thereafter, one letter has come under the police also. We have clearly written letter to on 14/9/2020, Deputy Secretary to the Governor of Assam, Health and Family Welfare, authorization of pay allowances and this. Here, Midler, for former portion is your lordship very hard. It is last portion I've done. I'm giving because my service to be also recorded.
Yes.
Here, lordship, inviting it to be. May I go to only short paragraph or latest last one? You are therefore requested to kindly intimate this office last paragraph, my lord, how the pay and allowances from the date of with effect of 16/10/1989 till the date of termination to be authorized to Dr. Mahanta in absence of formal taking of a charge report, and also intimate the actual date of termination of Dr. Mahanta from Gov service so as to enable this office to authorize admissible pay and allowances to Dr. Mahanta on receipt of register. This is why you are having handicap. These are all letters. And he also agrees, he might have learned also agree that papers are not being sent to us because all deal with this. And as a lordship or also, termination, we cannot give pension because 63B will work out rules until unless it's been happy and happy by lordship or something. It is streamlined internally. And that is my submission, my lord, my limited submission. Today also morning I have inquired. This is my submission, may be recorded. Today morning I inquired because earlier some other council is appearing. Today first time appearing. I inquired what is the latest progress. And this figure I have been informed morning onward that this letter which I have just now read before Lordship, 1492, reply has not come. That is my submission. I reply to them.
Yes.
Can you produce my our
Your name, Rohan?
Wrong. R.S. Wrong.
R?
R.S. Wrong.
You're for KAC.
Yes, Lord. Lord, may produce our affidavit, Lordship.
Well,
I'll
is
file
affidavit
it.
dated?
Lordship.
It filed when?
2021, Lordship. I'll better respondent number
First
7.
20th of December 21.
Yes, Lordship.
Okay,
Lordship may come to paragraph 5, Lord.
just a minute. By Karen Wrong PP?
Yes, Lord. Joint Director of Health and
Okay,
RBM.
okay.
Paragraph 5 of our affidavit, Lord.
Paragraph 5,
Yes, Lord. May I read?
please read.
That in pursuance to the notification number so and so dated so and so issued by the Undersecretary to the Government of Assam Health and Family Welfare Department, the petitioner was posted as MNHO-I at Bukajan CHC, Karbi Anglong. In pursuance of the order dated so and so, the petitioner submitted his joining report on 31/7/2000 at Bukajan. But the petitioner did not submit the taking over and handing over charge report, and as such, the same could not be forwarded to the authority and the Office of the Accountant General Assam for issuance of the payslip of the petitioner. As the petitioner did not take over the charge as MNH so-and-so at Bukajan CHC from Deputy Superintendent Bukajan CHC, the pay slip was not issued in the name of the petitioner. The petitioner also did not submit the charge report required to be submitted by the gazetted officer. The petitioner did not attend his duty at Bukajan CHC since 31/7/2000. The joining report of the petitioner was forwarded by the deponent to the authority of Karbi Anglong Autonomous Council for acceptance on 8/8/2000. And the authority of KAC issued the order accepting the joining of the petitioner at Bukajan CSC against the vacant post of so-and-so on 8/7/2001. So-and-so. But after issuance of the order of accepting the service of the petitioner at Bukajan CSC, also the petitioner did not take over the charge as so-and-so at Bukajan CSC and did not attend his duty nor inform the council. So this is our standard.
Yes, Mr. Goswami, anything?
Yes. This issue of joining and not taking over, handing over service, that is the reason why on time and again, records were called for that. You'll also be kindly, free, because that has been the live issue, so far as till his removal or till his termination, Now, so far as I had replied, filed a reply affidavit to the affidavit filed by the respond number 7, Health Department. In that, I had also annexed the letter which has been pointed out by my friend Mr. Borua, because a copy of letter dated 18/9/2020 was also served on me, which I received. Now, and in this affidavit, my lord, I have also referred to that the one order was passed by this court on 3/10/2019, my lord. After hearing the parties, my lord, The direction was accordingly pendency of this writ petition shall not be a bar to release the remaining 25% of the petitioner's total salary during the suspension period, keeping in view the financial condition of the petitioner as submitted by the learned counsel petitioner. The petitioner is given liberty to file representation, which I did, man. To the respond number 2 and 4 with supporting documents, and the concerned officials may scrutinize the same and release the same, subject to the satisfaction of the claim of the petitioner. My lord, I had annexed a statement of my entitlement, my lord.
Not
Not
this
say, not,
25%
my lord,
of your 25% of your.
that subsistence allowance. My lord.
No,
My
subsistence
75,
allowance-
actually, regular pay, my lord, 75% of I was paid. Since they had regularized my up to 2004, my lord, they have admitted, my lord. If your lordship sees that order passed on 2004, no? My lord, as per order dated 2104, my lord, whereby the first DP was closed, Annexure 5, page 44, my lord.
Okay.
The governor of Assam is further pleased to order that the period of suspension will be
Okay,
treated as
okay.
so that balance, so that much, so my lord, that is admitted, my lord. So in respect of this amount, my lord, there was a direction that there was no bar.
Okay.
I am placing this because, my lord, my friend had shown that letter to them because of which they are finding some difficulties, my lord.
Okay.
In fact, I had also annexed it to that letter. Now, my lord, this closure order was referred to my friend, Dipankar, my lord. But there, my lord, he says that posting is not necessary. It is assumed, my lord, that he was posted to Bokazan, so therefore no posting is necessary. But the direction was there from this High Court also. It is specified, past specific direction. That was not complied with, my lord. And in this order also doesn't even say that I was reinstated. Only that minor penalty, my lord, that was mentioned here, and then the period of suspension will be treated as on duty for all this purpose. Only these two things, my lord.
Let us see that.
That is at page 44. On perusal and going through the records of the case of the charges and statements of allegation leveled against PK Mohanto, and after careful consideration of the facts and circumstances of the departmental proceeding drawn against him, disciplinary authority is satisfied that the charge number 1 and 2 is difficult to substantiate. But the charge number 3 have been proved, as Dr. Mohanto had admitted that he performed 7 MT and 2 DIC cases on so-and-so in MMC, but the hospital authority could not produce any record of these cases.
Yes.
Considering the gravity of the charge number 3 level against PK Mohanto, it is felt that stoppage of promotion to the higher rank for a period of 3 years with effect from the date of issue of the order will meet the ends of justice. The governor was therefore pleased to stop promotion of so-and-so, so-and-so.
Yes, yes. We have read this.
Yes, man. Only this much, man. Doesn't even say that. Not to speak of posting, my lord. My lord, that was the issue, my lord. You pass an order posting me there, my lord. Because that is why I was not handed over the charge. And he says, I have not informed the joint DHS, my lord. That is my lord, the letter at 32 itself, my lord. When they did not accept my serving, there I annexed to page 32. This is addressed to the Joint Director of Health Services, Karbi Anglong Autonomous Council, my lord. This is my joining letter. And what did they do? After they waited for a period of 1 year to pass an order that accepting my joining on 31/7/2000 by Annexure 3. Copy of which was also served to Joint Director Health Service.
No, where is that direction from the court in the earlier round? Where you were regarding assigning a regarding passing of a fresh order for your place of posting?
No, it doesn't say but by the direction, my lord, if you read it in entirety, my lord,
we have read the direction.
Yes, my lord.
It would be open for him to seek all the remedies as may be open to him in
Yes,
law.
my lord.
As regards the other relief claimed in the petition, namely to permit the petitioner to join and function at his new place of posting,
My
this
lord.
court, however, directs 2 and 3, namely Karbi Anglong and so pass necessary orders within 7 days from the date of receipt of the certified copy to enable the petitioner to start functioning as so. At Bokajan, it says Bokajan. Same.
So that order that was necessary for him to pass, my lord, that was not passed.
It is not
7
necessary.
days, my lord.
Oh.
7
His
days.
service is continuous, my lord. There is
My
no,
lord,
there was no.
this
break, my lord.
direction was not complied by them. There's a direction, man, very clear.
After
Ottoman and in charge, Bokajan, respectively. Your lordship will kindly see. 2 and 3, namely Karbi Anglong Autonomous Council
Hmm.
and in charge Bokajan Public Health Center,
Hmm.
respectively, to pass necessary order within a period of
But
7
have you
days.
noticed, Mr. Goswami, this order of 28th of January 2004,
My lord.
whereby which the DP was closed,
Yeah,
RTR DP.
yeah.
You kindly turn over the page 45, see whom it has been marked. It is also marked to join DHS, MMC, as well as Karbi Anglong.
My lord. My lord, but this is of
This-
2004, my lord.
Yes, this makes it clear that everyone was in the know of things. Joint Director of KAC was informed by this order. You were as employee of under the Joint Director, posted at Bokajan.
My lord, in the writ petition, the issue was the same as we are agitating even now, my lord.
But
And
yeah,
thereafter, my lord, this
but where-
direction to
but where-
Karbi Anglong
Where
Autonomous.
is your explanation, which
My lord?
Mr. Bora is emphasizing, that you did not even submit an explanation?
No, my lord, that I have stated in my para, my lord. Yes, that first so-called notice, my lord.
24/2/2006.
My lord, at page 10, my lord, para 9, bottom. I know, my lord, where like, my that I have stated, my lord. It is not that I am
Now,
trying
what
to
have you
hide.
stated?
Well, I have stated at page 10, bottom, my lord, the petitioner though did not reply to the said letter dated 24/2/2006.
Hmm.
He had submitted a prayer petition shortly thereafter 1/6/2006 addressed to the Secretary of Government of Assam, praying for taking necessary steps. They admitted, I didn't want to, my lord,
Necessary steps
conceal
for-
anything.
Necessary steps for?
Praying for taking necessary steps for his joining in service in a place and to reconsider the penalty of stoppage of promotion imposed on him as aforesaid so that he can resume his service in a dignified manner. That is at page 10, bottom.
1/6 we have already annexed at page 49.
Yes, my lord. And I have also stated that I did not reply to that 24/2. Things like this happen, my lord. He is running from pillar to post, my lord. He's a man from Guwahati, my lord. He was posted there,
Mr.
not
Goswami,
aligned.
some we have to express that we find a big question in your bona fide.
My lord, that your lordship will find from their records. But the records your lordship will kindly see.
Which jurisdiction you have approached, equity court, your conduct is in grave doubt.
And my lord, this is clear that they did not pass any order in compliance of the High Court's direction, my lord.
That will
Within a
take care,
period
that-
of 1 week, my lord.
That will take care, but your conduct. Government servant,
My lord, I am, my lord.
2000, and we are in 2024.
My lord. And I have at every relevant state, my lord, I have made myself clear, my lord. You assign that posting and I will go. And Bokajan, my lord, why I could not take over charge, rather I was not handed over charge. That is my submission or statement, my lord. That is reflected from all my documents.
You are
And
now,
I informed the joint DHS, my
you are
lord.
now about 65 years.
My lord.
Okay. আজি সোনকালে কেইটাত উঠিব লাগিব আৰু কেইটা আছে মেটাৰ কি কৰে
My lord,
what is the next matter, Mr. Padiri?
Within 10 minutes, your lordship may discuss.
Okay, then we'll reserve this. Heard. So and so.
my lord, only one, my lord. My lord, at annexure 24, page 84, my lord.
Page
The-
84.
Yes, my lord, I have stated my entitlement, my lord, the benefits, both admitted and my lord, the other part, my lord. And the termination letter, my lord, did not say, my lord, from which date I was terminated. No date is mentioned there. That your lordship will kindly note. Annexure 23, page 82, which is impugned, my lord. It says, my lord, Therefore, in view of the inquiry report at age 83 and examination of the show cause reply, the Governor of Assam is pleased to remove Dr. Pradeep Kumar Dev Mahanta from service as per provision under rules so and so, so and so. This is dated 30th July, but no date is mentioned there from which date. It's quite vague.
Ancillary.
My lord, I prepared a list of date, my lord. And that to DPI and a copy of the representation that I filed after the order, my lord, which was passed by this honorable court, my lord. Directing me to file a representation with details, my lord. That copy, my lord, that is not on affidavit, but since it is there, my lord.
This is not recorded. What are the listed dates? List of dates.
कॉपी पे तो तुमको लगेगा ना.
Okay. How have you, what is the amount you are claiming now?
That is that. Page 84, my lord. The admitted amount, my lord, comes to about 2,21,000. And pending full salary and allowance from 1/8/2000 to 37/2018. That is termination, my lord, it comes to 1,28,080 and plus GPF benefits. But my lord, this is not exact, my lord, that I have stated. This is not.
GPS is how much? 1,31 lakhs.
Yes.
Yes, Mr. Bora.
My lord, regarding the amount of 25% of his salary, my lord, probably that government may consider. He may file a representation for consideration of that amount.
How
But
many
from-
representations, my lord? I have already passed.
But from 2000, my lord, the date since when he is not in duty, my lord, for that period, he is not entitled for anything, my lord.
Okay.
Because since the year 2000, my lord, after his joining at Bukajan, he is not performing any duty, he is not in government service, my lord. So from that date, he is not.
Heard. So, huh? Subhanam Dekhiba, Health Department, DP Bora, KC, HS Rohan, Aru, C Bora, HE. You're giving the records.
Yes, my lord.
Sri Bora, the learned Standing Council Health Department has also produced the records in original. Judgment is, hearing is completed, judgment is reserved.
My lord, this record is pertaining to the TP by the government, my lord.
Karbi Anglo records will be important for the joining part, my lord. That record has to be given by the standing council, my lord.
But my requirement, it would be there, as I have said it. That is a look. If they are late, they can request. They are not.
My record to 90. Huh?
It is the federal law.
My lord, on several occasions, my lord, direction was passed to the Karbi Anglong authorities to produce the records, and today, my lord, records is not there. What is this, my lord?
Earlier occasion we have.
Oh, my lord, when the case takes up, records should be there, my lord.
We can produce by date.
Thank you. আমরা photocopy আপনি করে রাখেন, photocopy. We'll have a photocopy of this, of
My
your
my
presentation.
lord, my lord. Can you do that?
Abhilashman.
My lord, Karbi Anglong record, my lord, my friend will give on
It
Friday.
was up to him, he has not
Yes, my
produced, what can we do? We cannot force him.
No, my
You
lord.
get the record, if you get the record,
Yes, Lord,
bring it
Friday.
immediately.
Yes, ma'am.
Yes.
Much obliged.
On Friday.
We have a limited issue. Well, the Department of Proceeding was issued against me. I was a constable. And basically, Lordship, I was dealt with the matter of pension matter. And in the Department of Proceeding, Lordship, one penalty that is one established of one increment with cumulative effect that has been imposed upon me. That is your Lordship will find at page 40.
40.
40.
Yes, thereafter.
After that, Lordship, I filed the departmental appeal, page 40.
Yes. Hmm.
I filed a departmental appeal, but that has been rejected,
Hmm.
appending this order. Well, so far the cumulative effect is concerned, that issue has already been decided by your lordship. That has been reported, lordship, in 2019 4 GLR 118 lordship, saying that the penalty which is not prescribed in the statute cannot be imposed. My lord, in the statute
1904 GLR.
2019 4 GLR 118. Lordship, I am giving that citation. Para 14, 16 and 17 is the order operative part, that is setting aside the order of penalty.
Where is the service manual?
My lord, so far the manual is concerned, the penalty that can be withholding of increment or promotion,
Hmm.
that much.
Hmm.
But so far the cumulative effect, that is silent. 66, rule 66, I'm giving you,
No, we have that. We have that book.
lordship. Rule 66, close, Assam policeman.
Oh, police manual.
Hello, all
It is
policemen.
not under the 1964.
No, he is a constable, lordship. Tukos notice was issued under the rule of section 98 of Assam Police Act, read with section 60, rule 66 of Assam Police Manual. Lordship, may I give it? Case 20 is the Shooter's notice. That was issued under section 98. Read with section rule 2066.
Proceedings to be drawn up in case of major penalty.
Well,
This is under what, which rules?
well, rule 66,
Of what?
Assam Police Manual. Lordship,
Mhm.
flag mark is given.
And that flag mark is, we know. The manual, what is the rule? Name of the rules.
Okay, Assam Police Manual. Okay.
Manual or not, manual is not a rule.
Police Manual Part 3. Read with in the Super's Lordship, page 20. 66 of Assam Police Manual Part 3.
I didn't take flag mark.
So, it was
That we know.
Second mark. Yeah.
section 98, that is also flag. Assam Police Act. Penalties prescribed are in the rule.
Okay, what do you say, madam?
Lordship. There was the main thing was that he was found, that means charge-sheeted for being showing his misconduct and indiscipline, Lordship. And he has given some undue favor while he is holding the post, Lordship. So there is breach of trust also. So accordingly, he has been show caused, and then the proceedings went on, Lordship, and this has been proved in all respect, Lordship. And thereafter, he has been given penalty, and this is not a major penalty. This is a minor penalty, Lordship, as prescribed in the rules, Lordship. And thereafter, the filing appeal, Lordship, in appeal also the order that has been passed in the appeal, this is also quite elaborate, Lordship, and this has been also mentioned there, how these things has been proved, Lordship, and that's why this has been upheld by the appellate authority also,
Hmm.
the findings of the disciplinary authority, Lord.
No, the submission is on a different footing.
Lordship.
He is not questioning the DP, the fairness.
Yes,
He is
Lord.
only questioning that the penalty imposed is not one which is prescribed by the rules.
Lordship, that count, Lordship, I just need to go through, may not be possible, Lordship, this one is, yes.
You
But
go
that-
to,
that
If
issue-
Lordship may can take it up tomorrow also, Lordship, if Lordship pleases.
Well, that issue was raised before the appellate authority and in the repetition as well. But in their affidavit, that is silent.
no, these are law points. Let her have a,
Yes,
let us,
one,
let her have an or days, time, we can have it tomorrow or day after tomorrow. Day
Day
after tomorrow.
Day after.
Tomorrow, Wednesday, it may not be possible. Okay, well, paucity of time did not allow the matter to be taken up today, full stop. Considering the issue involved, list for consideration. This is for hearing, has come for hearing.
Hearing.
List for hearing on
Second,
2nd May.
can it be a part of nothing?
This court bench is there.
It will go in supplementarily, bottom of the list.
Doesn't matter. This is the old matter. Matter of which year?
2020.
Not that
But-
old, Lord.
But still then, we'll try to finish up this matter. Technically, no?